unlicensed. Yeah, transporting a firearm in or out. Sorry?
That a 93-1 count.
Okay. Can you all hear us?
Good morning. Yes.
Good morning. Okay. We're having some issue with our volume. Okay. Right. Attorney Coulter, are you ready on Mr. Rashad Jackson?
Yes, Your Honor. It's a waiver.
Okay. Can I do it? Yeah. This is case 2260410, the people of the state of Michigan versus Rashad Omar Jackson L. Count 1, stolen property, receiving and concealing motor vehicle. Count 2, operating license suspended, revoked, denied, allowing suspended person to operate, second or subsequent offense notice, which is a misdemeanor, set for a probable cause conference today. Harrison.
Alexander Kirchner on behalf of the people, P86282.
Good morning, Your Honor and staff. Jennifer Colthurst, P52876. I appear on behalf of Mr. Rashad Omar Jackson L. Mr. Jackson, identify yourself. He should be in your waiting room.
Oh.
State your name, sir.
Rashad Jackson L.
Your Honor, I did have an opportunity to discuss this matter with Mr. Jackson L. He does wish to waive the preliminary examination. Correct, Mr. Jackson L?
Correct.
Okay, any objection from the people?
No objection, Your Honor.
Okay, Mr. Jackson, I'm going to ask you some questions. If you can't hear me or if you don't understand me, let me know, okay?
Okay.
Is it your wish to waive your preliminary exam today?
Yes, Your Honor.
Do you understand that you have a statutory right to a preliminary exam?
Yes, Your Honor.
And that if you were to demand that exam, the people would have to prove at the probable cause standard, which is a much lower standard in criminal law, but still a standard, that one charge I read off was committed in the city of Detroit and that you probably committed that crime. You understand that?
Yes, Your Honor.
That by waiving your preliminary examination, that means that people do not have to prove anything at that standard. Understood?
Yes, Your Honor.
You also understand that you are not giving up your right to trial.
Yes, Your Honor.
Knowing all of that information, do you still wish to waive your exam?
Yes, Your Honor.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. You will be bound over to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information date of July 24th at 9:00 a.m. And a couple other things. I don't know if it's on Zoom or if it's in person. It depends on who is the judge. And also Attorney Colthurst and Mr. Jackson, do I have both your permission to sign the waiver form since you all are both virtual today?
Yes, Your Honor.
Yes, Your Honor.
Okay, anything else from either party?
No, Your Honor. Thank you very much. I wish you and staff a very pleasant day.
Thank you, you as well. You're all set, Mr. Johnson, Jackson, excuse me, you can log off.
Bye-bye,
Okay.
everyone. So the person in the lime green shirt with the iPhone, what is your name, sir?
That's Mr. Sutton, Judge.
That's Mr. Sutton?
Yes.
Okay, thank you. To the person with the iPhone and no video, can you please state your name?
Mohammed Mozab.
You. Your attorney is logging on again. Let's see. Attorney Bazzi, are you ready on your client's case?
I am, Your Honor.
Okay, give me one moment here. This is case 2357606, the people of the state of Michigan versus Mohammed Mozab, charged with count 1, reckless driving causing injury, serious impairment of a body function, and count 2, police officer assaulting, resisting, and obstructing, except for a probable cause conference. Appearances?
Alexander Kirk, on behalf of the people, P 86282.
And good morning, Your Honor. Hassan Bezi on behalf of Mr. Mozab, who is present via Zoom. Mr. Mozab, state your name for the record, please.
Mohammed Mozab.
Okay. And
Judge, at this time, we're asking for a preliminary exam. I'm asking for July 31st. I'm actually leaving out of town either next week or the week after. We're still trying to get dates together.
okay, that's a Monday.
Yeah, is that fine with you? Or is there any other dates before that? I can do,
What other day can you do? So that's a little far out.
the 26th. I might be back by then.
That works. Can you do 9 o'clock?
Yeah, I just have to be in front of Judge Bryan at 9 o'clock. I'll be there right around 9 o'clock.
So you want me to put 9:30?
I'll be inside. Your Honor, may I just, well, we'll waive any time restraints also for the record, Your Honor.
Okay. Do you want 9:30 on the 26th to give you a little time?
Yes, that's fine.
Okay. Mr. Moses, your exam has been set for July 26th at 9:30 a.m. in person at 36th District Court. You understand that?
All right.
Is that
Thank
yes?
Yeah, yes.
Okay, you're all set.
Thank you.
Good day.
Your Honor, if I may,
Sure.
Your Honor, my client's on tether house arrest. He's currently disabled. He has to go back and forth to therapy. He's got to go to doctor's appointments, and he goes and sees, without going into too much record, he goes and sees a few people. I was just wondering if you could just remove that tether, Your Honor. He's 34 years old, no criminal history. I know the reckless driving causing serious impairment is a very serious crime. However, Your Honor, there's programs that are going to be eligible for him without going into too much of the details of the case. that it's in his best interest to show up to court. And he hired our firm right away, Your Honor. We've been visiting him. I've been to every single case. I mean, every single court appointment, and he is going to show up to every single court appointment.
Anything from the people?
People leave it to the discretion of the court.
Is your client working at all?
No, Judge, he's disabled, so he's going back and forth to different programs and also therapies.
Okay, so this is what I'm going to do. I'm not going to remove the tether, but I will lift the house arrest and any travel restrictions. He's gonna have a curfew of 10 p.m. to 6 a.m.
Okay, thank you, Your Honor. And would you submit that order to us?
I'm writing it now.
Thank you, Your Honor.
I'm just over to you as well.
I'm sorry?
I'll have it scanned over to you.
Thank you, Your Honor. Have a good day, dear staff. We'll see you.
Drop that, Mr. Moses.
Thank you so much.
Attorney Moss, good morning.
Good morning, Your Honor. How are you?
Fine, how are you doing?
I'm doing okay.
You waiting on your client?
I am, Your Honor. I have not had the opportunity to speak with my client, and I will tell you that I do have the digital discovery. However, I do not have the paper discovery.
Okay, do you want to adjourn this for a couple of days and try to find your client?
Yes, please.
Okay. Let me call the case. To be for Ronnie Curtis. Two, 3, 5, 7, 6, 2, 5, the people of the state of Michigan versus Ronnie Curtis, charged with 1 count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams, with a habitual offender fourth offense notice set for a probable cause time for today appearances.
Alexander Kirkner on behalf of the people, P86282.
Good morning, Your Honor. May I please assign Record Vanessa Moss, P63901, representing Mr. Ronnie Curtis.
Is it correct you have not been in contact with your client as of yet?
Yes, Your Honor. I've not made any contact with my client as of yet. And in addition to that, Your Honor, I'd like to place on the record that I am in receipt of the digital discovery. However, I do not have the paper discovery, so I'm asking for that so that I can go over that information with my client.
Mr. Kirk.
The paper was sent on the 5th, but it looks like it wasn't downloaded, so I just resent it just now.
Okay, thank you.
Okay, you wanna come back on the 14th?
The 14th, that's Friday, right?
Yes.
Thank you, Your Honor.
You are welcome. I'll see you then. You too. Attorney Hamilton?
Good morning, Your Honor.
Good morning. Who do you have today?
I have Mr. Charles Earl.
Are you waiting for Mr. Earl?
Yes, I have been in contact with him. This is actually a previous capias. And so we have spoken, Your Honor, but I'm wondering if we might be able to waive his presence and set a preliminary exam date.
Okay. Let's see. Okay, this is 2356592, the people of the state of Michigan versus Charles Earl. Mr. Earl is charged with one count of police officer fleeing fourth-degree vehicle code set for a probable cause now for today appearances.
Alexander Kirker on behalf of the people, P86282.
Vanessa Hamilton, PA2107, on behalf of Mr. Earl. Your Honor, we're requesting to waive his presence today and set a preliminary exam date. I have all discovery.
Okay. How soon, as far as days wise, what's the earliest date you can do?
I can do basically any day this week or next.
So how about the 17th?
Yep, we can keep that date.
Oh, okay. Let's do, 10:30?
10:30 works.
Okay, I will see you then.
Thank you.
You're welcome. Mr. Kirk, are you prepared for the second motion?
So man. 11 o'clock. Where you at? John. 30-ish. But too fast, but I enjoyed it.
Okay, Attorney Phelps, are you ready on Sutton?
Yes, Judge.
Case 25920, the people of Bishop versus Rico. Sutton, charged with count one police officer fleeing. Penal. Police officer assaulting, resisting, and obstructing with the habitual offender fourth offense notice set for a motion hearing today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, the 83355, appearing on behalf of Mr. Rico Sutton, who's also present via Zoom. Mr. Sutton, can you unmute your microphone and state your name for the record, please?
Rico Edward Sutton.
Thank you.
Today set for a motion hearing that is submitted by you, Attorney Phelps. And people last week asked for 1 week to provide a response. So I will let you start it off. Attorney Phelps, this is your motion.
Okay, Judge, for the record, I haven't received a response from the prosecution. I don't know if they submitted a written response, but that I do not have. So basically, it sounded like you had read the motion when we were here last time and you read the transcript. The court rules require that when the prosecution does try to refile charges on a case, that additional evidence to support the charge is presented. And Judge, from what happened at the first exam, There were 4 officers involved in this case. All 4 officers testified at that first exam. So I don't see any additional evidence that they are able to provide here. And I think that if, you know, what their issue may be is some of Judge Jones' rulings. And if that is the issue, then the proper remedy would be an appeal here, not refiling of the charges and having a new prelim before a different judge. So, and again, it sounded like you'd read the prelim transcript already, so I'm not gonna drone on, but I guess I reserve time for rebuttal depending on the prosecution's argument, Judge.
Okay, and yes, I did read through the transcript. Mr. Kirker, response from people?
Yes, during this week, we had an opportunity to review the file as well as read through the transcripts, and it is our belief that this would be better served as an appeal, and that there would be no additional evidence with the new exam.
Okay, so with that, I'm dismissing without prejudice.
Thank you.
And appeal in the event that they want to.
Great. Thank you, Judge.
You're welcome. You're all set, Mr. Sutton. You can log off. Your case has been dismissed. It's my understanding people may appeal this case, but as far as now, your case has been dismissed.
Thank you. Mr. Sutton, I'll give you a call when I'm done with court in like an hour, okay? You can go ahead and log off.
You're on mute, Mr. Sutton.
Oh, okay.
All right. You can log off.
Do I wrong? Okay.
Yeah. It's 16. This is 16. Yes. You know, I'm assuming that they added 13, 14, 15, 16, 17, 15. So they 1, 2, 3, 4. So they added 6 units to that.
Let me know if you use a that. Mr. Yancey?
I sure.
Mr. Yancey, can you hear me? The court?
Yes, ma'am.
Morning.
Yes, ma'am.
You have an exam in person at 10 o'clock, 36th District Court.
I thought it was over Zoom.
Did your lawyer tell you to zoom in?
No. Last time I came to court and it got rescheduled to today. It said today at 9 a.m. on Zoom.
No, I have here at 10 o'clock in person for an exam.
No, ma'am, I never got that information.
Okay, call your attorney to confirm.
I ain't gonna lie. I don't even know my attorney. I never met with one.
Okay.
I got rescheduled at the last minute when I joined the Zoom call on the 7th when I first got the information, the court information. And I was only on the Zoom call for like 20 minutes and I got rescheduled to the 10th.
Let me see. Hold on.
Yeah.
Oh, your attorney, Aliyah Davis. She scheduled your exam. She's calling out. Unless you're talking to your client right now. So easy in person, right? Hold on. Say it again. Okay, Mr. Yancey? Mr. Yancey? Julian Yancey? I received your motion. I just want to get this taken care of, so I. You are totally fine. I saw attorney taking cash. You know what I'm doing?
You want to talk to the prosecuting judge on a potential waiver?
This person, can you talk to him while we're waiting for Mr. Yancey? Thank you.
Mr. Vicker, please come in for Wilson.
Bigger.
Just a heads up, for that Morgan case, there's no defendant and no victim.
On Morgan?
Yes.
Okay, so I'll give them until this is over with. Thank you. Mr. Yancey, welcome back.
I apologize. My phone had died.
Okay, that's fine. I talked to your lawyer. She wants you to call her now so she can determine whether or not you all are gonna hold her exam today. So let me know when you're ready to take down her number. She wants you to call her as soon as you get the number.
Okay. Okay, I'm ready for it.
313
Uh-huh.
720
720.
5400.
400. Around.
720-5400.
Okay, thank you.
All right, go ahead and call her now. Okay, now, Mr. Joe.
Janet, I do believe that the MSP report is currently right there. I have not yet received it. Okay, cool. I just need a copy of it. Yeah. Thank you.
For some reason, Mr. O'Donnell will have his contact.
I know he's with India.
Oh, he is, okay.
Is Mr. O'Donnell with India?
O'Donnell?
O'Donnell.
I can check.
We're on the record, this is people of the state of Michigan versus Raccoon Lamar Jones. 2357388, Mr. Jones is charged with one count of controlled substance, possession, cocaine, heroin, or another narcotic, 25 to 49 grams with an individual offender report, as noted, set for exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Alicia Segura with the Neighborhood Defender Service on behalf of Mr. Jones, P86432. Mr. Jones, could you please state your full name for the record?
Waku Lamar Jones.
Good morning. Okay, are both parties ready to move forward?
Yes, Your Honor, if I could address the motion that I filed this morning.
Sure.
So this morning, as you are aware, I did file a motion to compel discovery, specifically body cam footage from the recovering officer. Upon initial review of the evidence.com link, there were multiple videos for both Officer Christopher Young and Officer his name's blanking on me, but Gibson, Lamont Gibson. And after reviewing those footages, for one, the prosecution did inform me that the labels of these videos were wrong. So actually the one labeled for Lamont Gibson was actually Christopher Young and vice versa. So I was not aware as to exactly which officer recovered the substances. However, after further review, the only footage that is of Christopher Young that is labeled is of 3 minutes of complete darkness. It is not on his person. I believe just from the audio that it is in the vehicle, and it just captures their radio, something about a homicide. Unfortunately, that is not relevant to this matter. Then again, upon further investigation, I reviewed the back seat footage of the squad car. And when Mr. Jones was removed from the squad car, and when they were searching for this alleged substance that was found, the video cuts out immediately prior to the substance being found. So I do not have any footage showing the recovery of the substance, or of the officer that allegedly recovered the substance. So I would just ask that prior to holding this exam, that I get that footage, if that footage does exist, because there is a lot in this case that just draws my suspicions that that footage is crucial to our defense here, Your Honor.
Keyword doesn't exist.
After speaking with the officers and the officer in charge, she told me that everything that did exist in this case has been uploaded. She offered to re-upload it to see if it corrects the issue with the one officer's body worn camera. I did review it myself and did see the same issue, that it's just a gray screen with just the audio. She also offered to contact the IT people that they have there to see if it could be resolved.
Are the officers here today?
The officers are here.
And Your Honor, I unfortunately am not aware as to where exactly the body cam is located. I believe it's on the chest. I did see a part of the body cam footage from one of the other officers. He did remove his body cam and place it on the hood of the car, and it did show the other officer, I believe, did not have body cam on at the time. When I did zoom in, it does not look like he has a body cam on at all. Obviously, I am not an expert into where these body cams are, but just from zooming in, it does not look like he has one on.
You want the opportunity to have IT try to open up whatever it is that you have an issue with, or do you want to, since the witnesses are here, the officers are here, do you want to wait to cross-examine or call them to the for example?
Yes, Your Honor. I guess I would, if they're here, then I'm fine with crossing them and asking them, about the body cam footage. I just wanted to let the court aware that there are some instances in this case that there is a concern regarding, why the body cam was not on.
Since you're here.
Yeah.
Yeah. Okay. Any other preliminary matters?
Not from the defense, Your Honor.
Yes, Your Honor. This time the people would move to advance the MSP lab reports under MCO 766.11B1A with agency number 23061000015.
Yeah.
Stating that the one clear plastic Ziploc bag holding one clear plastic Ziploc bag with a white chunky powder substance tested positive for 32.40 grams. Oh wait, never mind. It says that the test was inconclusive. The 42 non clear plastic bags containing the white material tested positive for 0.1069 grams of cocaine.
And you have had an opportunity for to review that this morning.
Yes, Your Honor, I just was given that, and I would just like to make the record clear that the 32.4 grams, it states that they did not show the presence of any controlled substance. So the only, on this report, it shows that only 0.1069 grams of cocaine was discovered. That's what it said.
Okay. So I will admit it as People's Exhibit 1. And before you bring in the first witness, I want to get these parties off the room. So off the record on Mr. Jones. Ms. Morgan.
Yes.
Morning.
Good morning.
Okay, you have an exam at 9 o'clock. Is she supposed to be on Zoom?
Yes.
Okay. Ready for it to be clear? Let's switch over to morning. One 1762147, people of state of Michigan versus Tamika Morgan, charged with 1 count of false pretenses, $1,000 or more for less than $20,000, set for an exam today at 9 o'clock. Appearances.
Alexander Cricker on behalf of the people, P86282.
Good morning, Mayor. It's for Your Honor, Attorney Damian Cash, number 85852, on behalf of Ms. Tamika Morgan, who appears via Zoom. Ms. Morgan, state your name for the record.
Tamika Morgan.
What's going on today?
They were moving to dismiss this case. The witness, this complaint is not available at this time.
Is that correct, Mr. Kirk?
That is correct, Your Honor.
Okay. Time is now 9:21. The exam is set for 9 o'clock. People cannot move forward without necessary witness, so I'll dismiss without questions. Are you still out there? I just wanted to. I didn't know what you were doing.
I was writing down notes.
Okay, so Ms. Morgan, your case has been dismissed. You can log off. Dismissed without
Thank you.
questions. Have a good day.
Thank you, Morgan.
You too. Thank you. Thank you, Mr. Cash.
Attorney Bickert, good morning.
Good morning, Your Honor.
You have Ms. Wilson, correct?
That's correct.
Okay. Just 1 second. Two, 357-635, the people of the state of Michigan versus Casey Wilson, charged with count 1 robbery arms, count 2 larceny from the person, set for a probable cause conference today. Appearances.
Alexander Cricker on behalf of the people, P86282.
May it please the court, Your Honor, Tyrone Bickert appearing on behalf of Ms. Wilson.
And Ms. Wilson is not present. Have you had contact with your client?
Yeah, I have not recently, Your Honor. However, I would indicate that this case was a dismissal. This must be a reissue. So I'm not certain as to what information she has about it. This case was dismissed on June 17th.
I don't have that here in the register of actions.
Your Honor, I was there I was there in person myself. The complaining witness had failed to appear and the case was dismissed without prejudice. I'm not certain of that date, but I am certain of that outcome.
Okay. It says the arraignment was held on July 1st, however, so she was arraigned.
This appears to be, yes, a reissue. Your Honor, I would ask the court respectfully if the court would consider allowing me to waive her presence. I can certainly try to secure her. I do have information with regards to an address and a phone number. She did appear, as I indicated, she did appear at the previous exam date.
Okay, so I do want to set an exam. I'll set it out a little bit further to give you more time.
Thank you.
How about the 20th or the 21st of July?
Checking now, Your Honor. You said the 20th or the 21st, the 20th. I'm scheduled to start a trial on the 19th. However, I strongly anticipated not to go. The 20th would be completely open in that case. The 21st has a couple things on it, but I could also do the 21st. So I guess maybe the 21st to be safe.
Okay, can you do 9 o'clock before you start all of your stuff?
I have an 8:30 schedule already. Could we try? Well, yes, Your Honor. Let's try for that.
Okay.
Well, can we do the 20th, Your Honor? I'm sorry. Can we do the 20th?
That's fine.
Can we do the 20th? So the 20th at 9 o'clock would be fine.
Okay. Perfect. Okay, hopefully you'll find fine by then.
All right. Thank you, Your Honor.
You're welcome. Have a good one.
All right. Take care. You too.
Attorney Rucker?
Good morning, Your Honor.
Good morning. 2357104, the people of the state of Michigan versus Jazzy Morris, who's defendant number 2 and charged with count 1, police officer assaulting, resisting, and obstructing, and count 2, which is a misdemeanor, disturbing the peace, for an adjourned probable cause conference. Appearances.
Alexander, you're on behalf of the people, P86282.
Tyron Ruck on behalf of Jazzy Morris, P number 61867.
Okay, your client was here Friday for the PCC, and she asked for it to be adjourned, and she was waiting a while for you, so she's not here today. How would you like to move forward?
Your Honor, I'd like to waive her appearance, and I think I'm still waiting on the, if I'm not mistaken, the discovery.
Mr. Kirk?
Discovery could be sent.
Okay.
I didn't hear him.
He said discovery can be sent over.
Okay. And Your Honor, please excuse my presence. I was there Friday. I had a 3 exams with the same person in a relatively high profile case, and I just couldn't get out and everything was turned off, but I was there.
Okay, we were calling you and trying to find you.
Yeah, it's in Judge Jeffrey's courtroom.
Right next door?
Ma'am?
Right next door?
Yes, ma'am.
You couldn't stop by after you were done.
What's that?
I said you could have stopped by after you were done.
Yeah, I could have. I'm sorry. But it went a while, though. I think it was like 3 exams, same person.
Yeah, we were here till 4:30.
Okay.
Okay, so I would like to set an exam date. If you need an adjourned PCC in between, that's fine, but I want to set an exam date.
Okay.
Yeah, just in case you misplaced or something. Go that way.
Do you want a call conference or just an exam date?
Yeah, just an exam date, I think.
Okay. Does the 20th work? July 20th at 10 o'clock? No, you're muted. I heard, it looked like you said okay, but you were muted. Can't hear you. If this is an okay day, can you just give us a thumbs up for July 20th at 10? Wonderful. We got a thumbs up. It's been set for July 20th at 10 o'clock. You're all set, Attorney Ryan. We're back on the record, the people of the state of Michigan versus Raquel Jones, 2357388. No need to put appearances on. We were in the middle of discussing these preliminary matters. There was exhibit 1, people's exhibit 1 admitted, and a motion or an issue of discovery that was discussed. Are there any other preliminary matters?
Nothing from the people.
Nothing from the facts, Your Honor.
Okay. Oh, before you do, the officer, okay. Any objections?
No.
Okay. You fight for it.
This time the people call Officer Christopher Young. And may I approach Young?
Yes.
Officer Young?
Court, then I'll swear you.
Excuse me, Judge, I apologize. Robinson did not check in yet.
Okay, thank you. You swear to tell the truth, the whole truth, and nothing but the truth. Okay. Door opens right here in front, just make sure you speak up in the microphone when you respond. Whenever you're ready, Mr. Curtin.
Good morning. Could you please restate your name for the record?
Police Officer Christopher Young.
Yes. Are you currently employed in a so in what capacity?
Yes, Detroit Police Department.
Yes. How long have you been employed with
What do
Detroit?
you say?
Probably
Right.
How long have you been employed with the Detroit Police Department?
since 2018.
And were you employed in this capacity on June 10th, 2023?
Yes,
Did you in fact work on that date?
yes,
Were you by yourself or with a partner?
with a partner.
And what is your partner's name?
Deals on Gibson. Badge 758.
And did your duties as a police officer take you to an area at or near Woodward and East Adams Ave?
Yes,
In the city of Detroit, county of Wayne?
yes.
And what brought you to that area?
There was a crowded area, a lot of people loitering on the church steps, drinking and smoking and stuff like that.
And when you say loitering, what do you mean by that?
Loitering, sitting on the steps, not supposed to be there. No loitering there.
And is this a civil infraction?
Yes,
And upon seeing this group of people loitering, what did you do?
We asked them to leave the area.
And did the crowd of people leave the area?
Yes, everybody separated.
Said except for the defendants?
Yes.
Is there somebody present in the courtroom today that you came into contact with on that tape?
Yes, sit right there.
Could you identify an article of clothing in that door?
Black male, brown suit, sitting next to the council.
Your Honor, let the record reflect the identification of the defendants.
So reflected.
And you said the defendants did not.
Yes.
On the defendants not moving, what did you do?
We asked them to move again.
And did the defendants comply?
No.
How many times did you ask the defendants to
I don't recall.
multiple? At this point, when the defendant was not complying with the commands, what did you do?
We get out the car.
Did you approach the defendants?
Yes.
Did you make contact with the defendants?
Yes.
And what did you do upon making contact with the defendants?
We observed that he was totally intoxicated. His eyes were glassing, alcohol from his breath. So we had him come over to our car, but this man is very close to a police officer, which we brought him tickets for all three of those things.
So you wrote tickets?
Yes.
For all, you said all three of those things?
Yes.
Was it?
It was for disobeying lawful order, loitering, and
I'm sorry, Mr. I just here. I didn't take over here.
I believe it said public intoxication.
Yep.
And after writing those tickets for the defendant, what did you do?
We didn't write the ticket there. We are taking them back to Sony Water and processing for historic conduct. And upon checking them before putting in our vehicle, the contraband in his underwear.
And when you say checking him,
I checked his outermost garment for weapons. And upon checking them for weapons, I feel something stashed in his underwear, inside of his clothing.
and can you describe what you felt stashed in his underwear?
It was a bag, with a small bag.
And in your experience, what did you believe this to be?
Narcotics.
And so upon feeling what you believe to be narcotics in the defendant's underpants, what did you do?
He asked him what it was.
Did the defendant respond?
I don't recall, it's mine, it's on video, not that video.
And you say you were taking him to 20 Atwater?
Yes, that's where we take, everybody who's, disorderly on the weekends, Friday, Sundays.
And when you said taking him, how did you take him there? Where was the defendant seated in the scout car?
He was sitting in the right passenger, behind the passenger seat.
And prior to leaving that evening, was the scout car checked?
Yes.
Was there anything discovered in the scout car?
No.
Were there any other individuals in the backseat of the scout car?
No.
Prior to the defendants? And did anything happen while you were transporting the defendants to 20 Atwater?
Yes, we heard, defendant moving in the backseat, and we asked him why he was moving, and we, let him know that he was being recorded on camera. And he kept moving until the point where we pulled him over. And when I put him over, I checked the defendant again, and that bag that was there was no longer there, and my partner recovered it from the back of the seat, which I observed.
And
I'm sorry, the last part you said, you pulled over. What did you say?
We put over, we got the defendant out of the vehicle, and when I get him out the vehicle, I rechecked him. And the bag that was there before, when I patted him down, was no longer there before.
Thank you.
And was this in the same location earlier that you had left the bag on the defendants? He said it was no longer there.
Ask that question again.
Did you check the same area where you had felt the bag previously on the defendants?
Yes.
And it was no longer there?
No.
And you said the defendant was then removed from the vehicle,
Yes.
and your partner then checked
Did
the back seats of the vehicle, and you said your partner made a recovery.
So you have to ask my partner that.
So did you observe your partner make a recovery? I have no further questions for this.
Ross?
Good morning.
Counselor?
Did you prepare a report in this case?
Yes.
Did you review that report prior to submitting it?
Did I review prior to submitting? Yes.
To ensure it's accurate representation of the event that occurred?
Yes.
And did you review that report prior to testimony today?
Yes.
And did you find any inaccuracies in that report?
Not that I recall.
Okay. When you stated today that when you first approached the, Mr. Jones, you had already told him multiple times to move from the area that he's currently in, correct?
Yes.
So when you got out of your car, you knew that you were going to approach Mr. Jones.
Yes.
And are you aware of the, DPD's policy on body worn cameras?
Yes.
And you're aware that when you have to activate your camera prior to initiating contact with the civilian.
Yes.
And you did not follow that protocol on this day.
On this video of my body camera.
I can't hear you.
This video of my body camera.
So unfortunately, I was not provided that body cam footage.
From over the weekend, they sent you an email and sent me an email saying that it was in there.
Okay, yes, well, as we discussed prior today, that was not in there.
Okay.
So I'm just asking you to ensure that even if it was, that you did not have that on at the time that you originally approached Mr. Jones.
I don't recall.
Okay. And then so upon making contact with him, you discovered that he was showing signs of intoxication.
Yes.
And you also said that he was loitering
Yes.
and that he was disobeying your orders.
Yes.
So you were going to cite him. Write tickets for him.
But when you're publicly intoxicated, that's the story, publicly disorderly intoxication. So that warrants you to go with 20-hour warrant.
Okay, so you cuffed him.
Had him down a cup.
Did you cuffed him prior to petting him down?
Don't recall.
So after you patted him down, you say that you discovered something, you felt something in his underwear.
Yes.
And you were searching originally for weapons
Yes.
to ensure your safety
Yes.
prior to placing him into the back of the squad car.
Yes.
And when you felt this contraband in your undergarments, you did not feel it was necessary to remove the contraband?
It was a Taylor Swift concert and a whole over maybe you can say 20,000 people in the middle of downtown in that area. To go in a man's undergarment in public like that, that would be improper. And that wouldn't even be humane for me to do that.
Okay, but if it was something that could have risked all of those people at the Taylor Swift concert, it would have been appropriate to remove it.
But it wasn't, I knew it wasn't a weapon, it was contraband, drug contraband.
You did not know, you just suspected.
Suspected.
Okay, so when you put him in the car and you were driving, you believe that he was moving about in the backseat.
Yes, so we adjusted the camera.
Okay, and he was handcuffed still at this time, correct?
Yes.
And you guys were driving relatively fast.
Yes.
Okay, so then you moved and you pulled over and you removed him from the car.
Yes.
When you removed him from the car, you were the one that patted him down the second time?
Yes.
Okay, and you did not, you weren't the one that recovered whatever was in the backseat?
No.
Okay. And have you had encounters with Mr. Jones prior to this?
Yes.
Okay, so you are aware of who Mr. Jones is?
Yes.
Okay, and so you even stated to him that you're sick of him and people that hang out, hang out.
Yes.
I have no further questions for this witness, Your Honor.
Right.
Enough further.
Yeah.
Ready for your next witness? we have one?
At this time, the people call Officer Lamont Gibson.
Officer Gibson?
State your name. Right here, sir. Right here.
Just where it tells you. Don't open record, but just make sure you speak up in the microphone. There's a lot of background noise and. Whenever you're ready.
Good morning. Could you please restate your name for the record?
Lamont Gibson.
And are you currently employed, and if so, in what capacity?
Yes, sir. I'm currently employed teacher, police officer, as a police officer.
And how long have you been employed as a police officer?
5 years.
And were you employed as a police officer on June 10, 2023?
Yes, sir.
Did you in fact work on that date?
Yes, sir.
And did your duties as a police officer take you to an area at or near Woodward and East Adams Ave?
Yes, sir.
Is that in the city of Detroit, County Wayne?
Yes, sir.
And what brought you to that area?
Just routine patrol.
And did anything happen while you were on this routine patrol?
Yes.
And what was that?
We saw a group ordering in front of the church.
And upon seeing this group loitering, what did you do?
I'm trying to order everyone to leave that area.
And did everyone leave that area?
No.
How many people remained in that area?
One person.
And is that person present in the courtroom today?
Yes.
Could you point out that individual and identify an article of clothing they're wearing?
He's wearing a vest, pants, and shoes.
Your Honor, let the record reflect the identification of defendants. And upon the defendants not moving from this area, was he detained?
Yes.
Defendant placed in the scout car?
No.
No?
Not immediately after he was detained.
And what happened immediately after he was detained?
I was detained, he was brought to the front of the vehicle, patted down for our video camera.
And what was the result of this pat down?
Due to the area being heavily populated due to concert with Joseph, we decided that we'd take him to the hour to finish our investigation.
At this point, was the defendant placed in the scout car?
Yes, sir.
Where in the scout car was
In the passenger back seat.
On the right or left side?
That's gonna be the right side.
And did anything happen while you were transporting the defendants to 20 Apple?
As the defendant was moving around the back seat, as he was adjusting his waistband or something like that. So what we did was we moved our camera to see a better view of him.
And why was it significant that the defendant was moving around?
To make sure he wasn't doing anything in the vehicle.
And you said you had moved the camera?
Yes.
Were you able to view that camera?
Yes.
Did you see these defendants moving around?
Yes, sir.
Did you see the defendant doing anything else in the back seat?
I think he was doing like a stepping motion towards the seats.
And in what area of the seats was the stuffing motion?
To the left side of him.
And upon seeing this stuffing motion, what did you do?
We went to pull it over, and we may have the defendant exit the vehicle, and we checked the location where he was possibly stuck or something.
And did you check this area?
Yes, sir.
And did you make any recoveries?
Yes, I recovered one suspected bag of cocaine and another bag of small bag of cocaine.
And where did you make this recovery?
And that left suspected area where he was possibly stuck.
And could you describe the item that you recovered?
The first item was just loose, like cocaine, like crack cocaine almost. And then the other one was 40 small little baggies of possible crack.
And were these items placed into evidence?
Yes.
Do you recall the evidence tag number?
I could refer to my report, but I can tell you right off the top of my head.
Was reviewing your report, refresh your recollection?
Yes, sir.
Were you given a lock seal number?
Yes, sir.
Do you recall that lock seal number?
I have to.
Your Honor, may I approach? And do you recall the lock seal number?
From the state, like, right now?
Yes.
You need to keep it. It's I'll have to look at this number's pretty long.
Is there any objection to witness reading the number?
Yes. Yeah, it's fine. Go ahead.
It's gonna be 0057488874.
I have no further questions.
Yes, sir. Officer, you prepared a report in this case.
Yes.
You reviewed that report prior to submitting it
Yes.
to ensure it's a fair and accurate representation of the events that occurred.
Yes, ma'am.
Did you review that prior to your testimony today?
A little bit.
Did you review any inaccuracies in that report?
No, ma'am.
You allege that when Mr. Jones had something on his person during a pat down, it could be felt he was under garments.
I am putting my partner there.
Your partner did.
Yes, ma'am.
But your partner did not pull out whatever it was.
No.
And you yourself did not visibly see it, like whatever it was inside at that time.
At that time.
And when Mr. Jones was then placed in the squad car, he was handcuffed, correct?
Yes.
And when you approached him, it was because he was intoxicated or visibly intoxicated. Loitering. These are ticketable offenses.
Yes.
At some point, the car was pulled over
Yes.
and Mr. Jones was removed from the car.
Yes.
And he was again patted down.
Yes.
But you yourself did not do that pat down.
No, I didn't do that.
You were the one that recovered whatever it was from the back seat.
Yes, ma'am.
You were not wearing a body cam at this time, right?
At the time during this whole investigation? Yes, I was.
When you recovered the suspected narcotics, you did not call narcotics on scene, did you?
No.
No. And you did not receive a lock seal number at that time?
No.
You did not count out the baggies on camera or anything of that sort?
We got that place, but not on the scene.
And you are familiar that with contraband, it's always best to preserve the evidence as soon as you can, correct?
Yes.
I have no further questions, John.
Right. And further, Your Honor. None from the people.
No, Your Honor.
At this time, the people would move to find over the defendants on amended count one, which would be controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. As we heard from the officers, while on routine patrol, they observed a group of individuals loitering on Adams and Woodward Ave. At this point, they asked the group to leave the area, which all complied except for one individual. That individual, both officers identified as the defendants, was then cited for public intoxication, disobeying a lawful order from the police, and loitering. He was then detained, and prior to being detained, was patted down, at which point Officer Young testified to dealing with what he believes to be narcotics in the undergarments of the defendants. Based on the large crowd that was present due to the concerts, the defendant was then placed in the scout car to be further searched at the 20 Atwater. However, while en route to 20 Atwater, officers observed the defendant moving around in the back seats, observed him making a stuffing motion toward his left side. Based on these motions and the defendants continuing to do them, officers pulled over and removed the defendant from the vehicle, at which point he was then patted down again. This time, the officer no longer felt the suspected narcotics that he had previously felt. Officer Gibson then searched the area where he had observed the stuffing motion by the defendants, at which point he recovered a baggie with a unknown white powder that he suspected to be cocaine. People believe that the very probable cause of the development.
Your Honor, we object to the bind over in this matter. The prosecution has failed to present evidence even by a probable cause standard that Mr. Jones actually or constructively possessed cocaine. As the officer testified, the alleged narcotics discovered in the squad car was never once observed on Mr. Jones's person. While they did feel something in the back of him, they never pulled it out. They never seen it physically until after he was pulled out of the squad car and it was discovered in the car. There was nothing to show that Mr. Jones had possession over that item, had control over it. So there is nothing to prove or show that he actually or constructively possessed it as necessary in this circumstance. Additionally, once they removed Mr. Jones from the squad car, there is no body cam footage, at least that has been shown to show what exactly was recovered. And further by the MSQ report that was provided, a large portion of that suspected narcotics did not even test positive for a controlled substance. In fact, only 0.1069 tested positive for cocaine. That is a minuscule amount, Your Honor. Further, it cannot be ignored that crucial parts of this encounter are not caught on camera. Officer Gibson admitted to not following or at least not having that body cam footage. They were aware that they were going to approach Mr. Jones prior to even getting out of the car, and there's no footage to show that. So we would just ask for those reasons that this not be comes over.
Your Honor, I believe it'll be a question of fact as to constructive possession. The officers testified to prior to going out that evening, the scout car was checked for any items in the vehicle. On checking the vehicle, nothing was recovered. As Officer Young testified to, the defendant was the first person to be placed inside the scout car that evening. The officers observed what they believed to be a stuffing motion on the defendant being pulled out of the car. The spot where Officer Young had felt the suspected narcotics, he no longer felt them there. And Officer Gibson searched the area where he observed the defendant to be making a stuffing motion in that location. The narcotics were recovered. So again, people believe that the first probable cause of it.
I do believe that people have been for proof here today. It's a question of fact. We're trying back. There's enough evidence based on testimony between two officers that the defendant at minimum had constructive possession of the drug that was found stuffed backseat of the squad car. Constructive possession is where the defendant had knowledge and ability to control And that can be inferred based on testimony, and testimony from both officers that after the pat down from the initial contact with the defendant, for pat down for safety for weapons, that Officer Young felt what he suspected to be drugs, although that the drugs were not identified at the time, and also in consideration of the defendant's privacy. The officers decided to finish the pat down and search in privacy at the Atwater location. On the way to the location, officers both heard moving from the back seat, and the second officer stated that he believed the defendant to be stuffing or making a movement as if he was stuffing drugs in the back seat. Based off of that, the officer stopped, pulled the defendant out, found drugs in the back seat. There was also testimony that the officers did not have any drugs that they knew of in the backseat prior to arresting the defendant. Although it is a very minuscule amount, 0.1069 grams, the charge just says less than 25 grams, and with that one amount is still satisfactory for bind over. So Mr. Jones, I am going to bind over to Third Circuit Court. Your arraignment on the information date will be 2 weeks from today, since you are not in custody. It'll be July 24th at 9:00 a.m. And whether it's in person or on Zoom will depend on which judge. Anything else? Okay, let's continue. You're all set, Mr. Jones.
Or in here. Yeah, so they just give me PCC for July 24th, but I'm gonna be out until August. I already talked to my client about that delay. So I can come in, I can do the Zoom PCC on the 2nd. And I could do that. Do you need the, yeah. You don't want to just guess. Okay. EP05.
Mr. Yancey, did you talk to your attorney?
75.
Yes, ma'am. Yes, ma'am.
Okay, are you, well, it's 10 o'clock now, so are you planning on waiving?
Yes, ma'am.
Okay, so as soon as your attorney logs on, then I will address your waiver, okay?
Yes, ma'am.
Right, Nelson.
Nine thirty.
About the way.
What time was it? Mine, oh, mine's a dismissal.
We'll have that first.
Yeah.
You wanna get your client?
Yeah. that's-
I have it. Okay.
Thank you, that's appreciated.
Let's check. What happens?
I had a defendant who called through, he said he was in the waiting room for his PCC this morning. It was for 8:30, but he said he still hadn't gotten Talipro.
Wars, the Jazzy Wars and one.
Yes.
I wonder if he got disconnected, because he said he's been on there since.
He's not in prison. We're here. His name is what?
Talifer? What's the, he would just do the courtroom? Do you have him on there for today? Do you have Talifer on there for today? When I pulled up his ROA. I pulled up the ROA. Maybe it changed since.
Judge, Aliyah?
Aliyah, Sabree.
So for Ryan Adams. Next.
Oh, okay, so he's just.
Record, this Judge, Sabree. I don't know that. They, this is CCW. Just Robinson, that's what he was.
Oh, that's. 440, okay, thank you, maybe he was in the wrong.
Okay, ready? Okay, thank you.
Yes.
2357369, the people of the state of Michigan versus Ryan Christopher Adams. Mr. Adams is charged with 1 count of assault with dangerous weapon, felonious assault, with an habitual offender for the defense notice set for an exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Morning, Judge, to you and your staff. Rick Nelson, P39317 on behalf of Mr. Adams.
Adams, can you state your full name for the record, please?
This is Brian Christopher Adams.
Good morning to everyone. Are the people ready to proceed?
The people that are not, Your Honor, they can say this is the prison.
Okay, I will dismiss without prejudice as the people are not ready to move forward. The time is now 10:05 and time is set for 9:30. I have filled out the dismissal form. Should not take long to do. Anything else from either party?
Nothing.
Okay, you're all set for wait hallway.
Thank you, Your Honor.
Check.
Ms. Jazzy Morris, unmute your device.
Hi, this is Jazzy Morris.
I know, good morning. So you're late today, but your attorney did check in. So we set your exam date. Are you ready to take?
I was actually pulled over by the police, so that's the only reason why I was late.
Okay, I didn't put issue a warrant. I just let your attorney go ahead and set your exam date, okay?
Okay. So what's the so it's a different a date?
Yes, this will be for an actual preliminary examination.
When is it?
Give me a second. We called it already. It is July 20th at 10 o'clock.
July 20th at 10 o'clock?
Yes. In person.
Is it on Zoom? Is it on Zoom or is it in person?
In person at 36 District Court.
Okay, July 20th, 10 o'clock, 36 District.
Yes, that is correct, Ms. Morris. You're all set.
Okay, thank you.
You're welcome. Ready on Yancy?
Yes, ma'am.
Okay, 2357016, the people of the state of Michigan versus Julian Yancey. Mr. Yancey is charged with 1 count of stolen property, receiving and concealing a motor vehicle, set for an exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Aliyah, Kahlilia Davis, P70729 for Mr. Yancey, who is present via Zoom. Both of us are actually present via Zoom. Mr. Yancey, will you state your name for the record?
My name is Julian Yancey.
Thank you.
Okay, I have is it correct your client will be waiving his exam today?
Correct, yes, Your Honor. I have explained to him the nature and purposes of an exam and his right to hold such an exam. And if the officers are not present, if the officers are present, then he would like to waive the exam.
Okay. Okay, are the witnesses present on Nancy?
The witnesses here on Nancy.
Yes.
Okay.
Officer.
Okay, Mr. Yancey, I'm going to ask you some questions. If you can't hear me or if you don't understand me, let me know, okay?
Yes.
Is it your wish to waive your preliminary exam today?
Yes.
Do you understand that you have a statutory right to a preliminary exam?
Yes.
And that if you were to demand that exam today, the people would have to show at the probable cause standard, which is a lower standard in criminal law, but still a standard, that one charge I read off was committed in the city of Detroit and that you probably committed that crime. Do you understand that?
Yes.
And that by waiving your exam today, that means the people do not have to present any evidence at the probable cause standard today. Understood?
Yes.
Knowing that information, do you still wish to waive your exam?
Yes.
You also understand that you are not waiving your right to trial.
Yes.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. You will be bound over to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment on information date of July 24th at 9:00 a.m. Depending on who you get as a judge, it will determine whether or not you are in person or on Zoom. You have to check with your attorney, okay?
Yes, ma'am.
And Attorney Davis and Mr. Yancey, do I have both of your permission to sign the waiver form since you all are virtual?
Yes, Your Honor. Thank you very much.
Thank you. Anything else from either party?
No, Your Honor.
Okay, you're all set, Mr. Yancey. You can log off.
Okay, thank
you,
you.
Your Honor. Have a good day, Your Honor.
You too. Thank you.
Recall Adams.
Trying to run out these here.
Okay. Which is address, nothing said, well, I've been there since the other day. Well, that should have cost council. Actually, there's also two.
Is Attorney Nat here?
No.
No,
You're well, not co-counsel, but.
Yeah, the other attorney, he's the one who scheduled this. I actually checked into Judge Robbins early, went to the courtroom and came back, and Judge Robbins asked me if it was scheduled at 8:30 today, and that was okay. I'm having tunnel surgery where my whole left arm and now I'm absolutely miserable. So I have a million things to do today before I can't wet my hand this week, like wash my hair, stuff. So, I don't know if you want to call house counsel. My client's in custody. I'm assuming they're here. Is Mr. Boyd in custody as well? The co-defendant, because I didn't see him out there. Stephen Moten?
No, he's not.
Oh, well, next day.
Stephen Moulton is in the hallway.
Oh, he is his attorney there?
Nope. Your client is down.
I can try and locate, call his attorney if I knew the first name, I can Google.
Officer
his phone number.
I've tried calling him.
Nothing.
Here, I'll give you the bill so that you can try while we do this.
My client has a parole detainer. Oh, wait, does he? No, he's on probation.
Something else in there, because I don't think it would be excessive.
My client? Yeah, so if we have to waive 14 days, we can go out on this if we want to wait for the other attorney. I absolutely will text them and find the number.
Okay. Yes. Oh, Leslie now. 734-421-2610. After this waiver, I'll bring it back in so we won't be sitting here on there.
Actually, I have a PCC in front of you tomorrow. By the way, it's nice to meet you in person. Yeah, and I'm sorry I don't look so terrific.
Oh, no.
But it's a pleasure, and I will call Leslie and see if I can get a hold of her and text her.
Okay, thank you.
You're welcome.
So. Trying to contact them. And that doesn't turn back. Welcome back. Bring Mr. Adams in.
Third time calling, no answer, left a message.
Now,
Yeah.
the recall for Brian Adams, people will be Brian Adams, 2357369 appearances.
Alexander Kirker on behalf of the people, P86-282.
Good morning again, Judge. You and your staff, Rick Nelson, P39317, on behalf of Mr. Adams, present again.
Mr. Adams, can you state your name again for the record, please?
Yes, Brian Christopher Adams.
Okay, there's some updated information that I received. Is it correct, the complaint which is reviewed the whole time?
Yes, it's my understanding.
The request from the people?
The people request that the dismissal be rescinded.
And the complaint which was in the way, in the legal way?
I believe so.
Correct, Judge.
Okay, that would be unfair based off of the information I received to dismiss this case. So I will rescind the dismissal. I do have a waiver form here. Correct, your time, we waiving the exam.
Yes, Your Honor, I've had a chance to go over my client's rights on a couple of occasions. I've seen the form in front of the signature, he's aware it's problem cause standard, aware that waiving doesn't mean he's guilty. This means he's giving up the problem cause standard, we've not go to circuit court on the charge of felonies.
Mr. Adams, is that correct?
Yes,
You also understand that you are not giving up your right to trial?
yes, Your Honor.
Any objections on the people?
No objections, Your Honor.
Did anyone force you, Mr. Adams, or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be really understandingly and voluntarily given. You will be bound over to Third Circuit Court for your arraignment on the information date of July 24th at 9:00 a.m. Depending on the judge you get, it'll determine whether you're in person or on Zoom, and your attorney will figure that out. Okay?
Okay.
And bond to continue. Anything else?
No, thank you very much.
Great. You all have a good rest of the day.
It looks like, Mr. Rose and I retained counsel on this here.
Got it. Okay. Okay, let's bring everybody in.
Nice to meet you, Judge.
Nice to meet you.
I'm still trying to.
You know what, you shall log on?
Yes. He said he was there, but I'm like, I don't see you, so what's going on? I'm getting,
I have a Ronnie Curtis in the waiting room, so here, I'll let that person in.
Ronnie Curtis, that was the first defendant, I mean, first person.
Oh, okay. I'll let it in, keep chatting today. Mr. Curtis?
Yes.
Okay, your lawyer checked in at 8:30 and gave you, or rescheduled an exam date. Is that correct?
I'm sorry. I'm sorry. I'm trying to work this phone. Can you hold on?
Oh, there we go. Okay, you said what now, ma'am?
Give me a second, I actually don't remember what happened. Your attorney logged in at 8:30. You're almost 2 hours late for today.
Yeah, I really do apologize for that. I kind of overslept. There's no excuse for that. But as soon as I woke up, I hopped on here. I thought it was at 10 o'clock though. I will say that my alarm went off for 9:45.
Okay, she saved you from a warrant, I can tell you that.
Oh wow. Okay, so I just what is my next step? I apologize for all this.
Can you see the chat? The clerk just messaged you all of your information.
The chat.
You should see a message popped up, or that you have a message at the bottom.
Your case was adjourned of 7/14/8. Okay. I'm gonna screenshot this. And you said I had a female lawyer?
Yes.
All right, because I did hire a lawyer, but I guess he just didn't. What should we call it? So 7/14, 8:30. All right, thank you.
You want to talk to your lawyer?
Sure.
Okay. Her name is Vanessa Moss Wilson.
Let me get a pen real quick. You said Vanessa?
Yes, Vanessa Moss Wilson.
You're saying long, like go long for a catch?
Moss.
Lost?
Like C Moss. MOSS.
Oh, Moss. Vanessa Moss dash what?
Wilson.
Okay.
248.
Okay.
358.
358.
6998.
6998.
Contact her. Log off of here. Call her because she has been looking for you. I will see you on the 14th.
Okay, thank you. Have a nice day.
You too. Okay, ready on Patman.
That's right.
This is case 2357359. People of the state of Michigan versus Aaron Patman, who is defendant number 1, and Stephen Moten, who is defendant number 2. Both defendants are charged with count 1, breaking and entering a building with intent. Both defendants charged with count 2, malicious destruction of a building, $20,000 or more. Count 3, defendant 1 is charged with burglars, tools, possession with an habitual offender, force offense notice for both defendants. That's for an exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Judge Sabree, Rosemary Dare, DAHER, P37888 on behalf of Aaron Patman.
Morning, Your Honor. Mark Bawada, numbers 58029 on behalf of Mr. Moten, who's present in court.
And Mr. Moten, please state your name, please.
Stephen Maurice Moten.
And Mr. Patman, please state your name.
Aaron Patman.
Okay. All right, so first of all, Attorney Awada, you said?
Yes, Your Honor, I apologize for retarding this. Mr. Core, who I work with, was supposed to do a turn-in Westland this morning. And they kept him at the hospital on Friday when he went in for testing. He was supposed to be getting a procedure done today. At least that's my understanding of what's going on with him. So I had to go an hour to Westland where I'm at and then get over here as quickly as possible.
But it's also my understanding you were just retained on this case?
Yes, Your Honor. I did receive discovery. They did email it to me and we are ready to proceed.
Oh, okay. Yeah. Okay, are the people ready to proceed?
The people are, Your Honor.
Any preliminary matters?
None from the people.
Just request that the witnesses be sequestered.
Okay. Is anyone on Zoom or YouTube who may be a witness or testify in this case? Now is your time to log off. Same in the courtroom. If there are any witnesses or anyone who may testify in this case, now is your time to exit the courtroom. Call your first witness.
People call John Primack.
John Fryman, PRYMACK.
Plastic COVID.
Yeah.
You can walk in front now. I'm swear you in. You swear to tell the truth, no truth, and nothing but the truth.
I do.
Okay, the door opens right here in the front. Just make sure you speak up in the microphone. Whenever you're ready, Mr. Director.
Morning, could you please restate your name for the record?
John Fryman.
And I want to take you back to the date of June 8th, 2023. Do you remember that date?
Very well.
Were you at 1373 Maple Street?
Yes, I was.
Is that in the city of Detroit, county of Wayne?
Yes.
And what is that location?
It's a substation by the City of Detroit Public Light Department.
And who was the owner of that?
City of Detroit.
And what is that building used for?
It's a substation which is used for power distribution. At this time, it's decommissioned. We're in the process of using the facility in the future, but at this time, there's no power in that facility except the low voltage.
And do you work at this location?
I'm the director of public light in the city of Detroit. There is nobody on site there permanently. We do go by randomly to do upkeep and check on our assets.
And when you say we go by, who would have access to this building?
Me?
Just you?
Yes.
And when was the last time that you were at this location?
The day I got called by the police department to come there, the break-in.
Was that June 8th?
Yes.
And did you lock up this building before you left?
Prior to that, you come to that building on the 18th?
Yes.
Yes, it is locked.
And were you the one in control of locking and securing the building?
Yes.
Who would have access to this building after you locked and secured it?
Nobody.
Now, did something happen that brings you into court today?
Yes, facility was broken into. It actually was destroyed. We have switch gear. We have transformers in there. The police came, called me about a break-in. I let them in the facility. I saw that what happened there. And they called the night before that there was a break-in. Met them there the next day.
So you made the scene?
Yes.
Okay. And
I'm sorry, I can't, it's hard to hear him. Could you repeat what you said about the night before?
I was called by the police department that there was a break-in at the facility.
and is there an alarm system for this building?
No.
And so after you made the scene, you said you let the police in?
Yes, we went there and went to the facility to see what kind of damage was done inside the building.
And what damage was done to the building?
There was transformers knocked over, oil spilled off the facility, and a lot of material taken.
And what material was taken?
Copper.
And did you see any damage to the exterior of the building?
Oh, yes, they broke into the rear of the facility. So they had some sort of cutting tools. They cut into the back doors, which is on the outside.
And as you had stated prior, were these back doors locked?
Yes, correct.
And did anybody have permission to take these items?
No.
Did anybody have permission to damage the building?
No.
Did you get an estimate of the damages to the building?
I went through myself and reviewed the situation. As in the past, I know that that's what it costs to clean up a facility. When they tip over transformers, oil in the ground, I have to bring in basically a test for PCB oils, all those things that go. More than anything else, I think the value of the material done in the facility had excess of $10,000, $15,000 plus the damage to the facility from the oil. So you're talking over $20,000 in damage to the facility.
And did you make any other observations of the building this time?
Your Honor, I'm going to object to the response that you gave. It sounds like he's speculating as to how much the damages were. I'd like to play a proper foundation so it's fixing
Right, that would be for the response, which you said in excess of 10, 15,000 for the damage of materials plus whatever the cost would be for the exterior. That response?
And then immediately after that, it sounded like he was taking a guess as to how much the rest would cost, just coming up with the figures. I'd like.
I can elaborate on that.
Can you ask the questions to elaborate? Lay the foundation as to how he would done.
Yes, so how did you assess these damages?
As in the past, we've had these circumstances at our substations in the past. As I've had the same sort of situation, the city of Detroit has paid those bills in the past. So this is not a one-time deal. The city of Detroit, as you know, we have a lot of break-ins to facilities. So this is another facility that broke into and had the same sort of damage.
And you had been part of assessing these damages in the past?
Yes, I am.
And I just wanted to clarify, you had said $10,000 to $15,000 in items taken, correct? And that was separate from the damages done to the building?
Correct.
And your estimate for the damages done to the building was what?
Well, right now it is continuous boarding up, police, security. So I can make a rough guesstimate that probably the whole transaction probably exceeded $20,000.
One objector stated within the response he's making a guess, so.
And I would also join in the objection.
He did say yes. So, that's what it is. It is speculative. I'm aware.
Thank you.
When you had previously dealt with the damages that were present in this case, how much did it cost to repair?
Usually, some of the facilities, somehow it's been acknowledged that some of these substations are basically decommissioned. So we're not putting them back in operation. So we're actually decommissioning the facility. So the major, I guess, price of this is we drain the oil out of the facility and testing the PCBs through all the substations. Now they're being kicked over in all the facilities, I have to bring in a crew to do those processes. So it's not basically just transporting oil out of the facility. Now I got to bring people to go through the whole facility where it was built on the concrete. So it's more than just sucking the oil out of the facility down all over the floors. And plus, they're tipped over. So it's more than just basically a facility where you're just taking an asset away. They're destroying the property, so I have to take care of the issue that's tied to that. That's the main power type of equation.
And how many people would it take to clean this facility tested?
Well, in the past, all the substations that have taken care of in the last year, we've probably taken on about 7 or 8 of them. The average cost of cleaning out a facility is about $30,000, $33,000 to $35,000 I pay to clean out the facility. And that's by recuperating the assets of the copper in the facility. So with the copper being taken, there's no asset to recuperate. It's going to probably do more than that.
A little bit more than that, 33.
Well, so exactly, probably the ballpark. I haven't been there. Going there this afternoon with our crew, getting the key to total damages there. And we'll have I have a better answer for you, but obviously there was issues when they take torches, they cut out the bottom of the transformers and the oil is on the ground on the facility.
So your answer for the damages is somewhere in the 30 to 33,000.
Yes.
And is that adding in the missing copper that was taken?
Correct, I believe, yes. I would just like to understand if I could, that's a question. How would they know this facility was not power decommissioned? I'm just curious for that information.
Witness was not allowed.
Oh, no, that's okay. Okay, thank you.
I was waiting for an objection, but,
Objection, Your Honor. I don't even understand who he's asking that question to.
well, I was under an answer, question answered from the prosecutor, the defense counsel has to.
Okay.
I have nothing further to this witness.
Okay, well,
Good morning. How are you today, sir?
Great.
So you said the last time that you were in that building was on June 1st prior to this incident?
No, they didn't say that. I
What?
said,
Okay.
I
What?
said I was there the day that the police called me, but I was there 2 days prior to that. That's silly also, but they called me the day when it was broken into, showed up.
Okay, let me just ask some questions, just to get a timeline. When was the last date you were at or in that building where nothing was damaged or taken
The
from
day
it?
before,
What date was that?
I believe it was the 7th. No, I'm not sure it was because, the reason I know that date was because I met the people in the city of Detroit on that site that were taking building retreating on the building. So whatever day that was, and so the day before the,
During the day?
yes,
So you went inside of the building and inspected the whole thing?
yes.
And there was no damage? Sure. But did you tell the police that you observed people there on the evening of the 7th or early morning of the 8th?
I did not say that. I said the police told me when there was a break-in that evening. And I showed up the next day to go through the facility with the police department.
Did you state that there was a break earlier in the night? You were responding to damage. Upon checking the rear of the building, you observed an older model blue pickup truck, correct?
Yeah, correct. That's when I was waiting for the police department to come there, correct?
Sometime early on the 8th.
That was the 8th, the day that I met the police, are correct?
What time approximately?
Probably around 9:30, 10 o'clock in the morning, I believe. I don't know exactly when it was.
What else did you see besides the older model dark blue pickup truck?
3 people came running out of the building.
Could I identify those people, correct?
I'll be honest with you, I wasn't, I was sort of shocked. And
So this is a yes or no
No.
question. Could you identify whether they were white or black?
Yes, 1 white woman and 2 black men.
And where did you see those people go?
Pardon me?
Where did you see those people go?
Run down the alley,
And what?
that was it. I had no intention of pursuing.
Did you see them ingress the dark blue pickup truck? Did the black dark blue pickup truck leave when they left?
They circled the building a couple of times, I think, because the tools were left behind.
That's not the question I asked. I would ask the court to directly just answer the question I'm asking. Did you see the blue pickup truck leave the scene when the 3 alleged suspects left the scene?
No,
Did you know that the blue pickup truck left the scene at any time?
no,
So the blue pickup truck was still there when the police came?
no. The blue pickup truck circled as the men left the building.
Did the blue pickup truck leave the scene or was it still on the scene when the police came?
They were gone.
So it left the scene. Did you do anything when you saw suspects going to the 3 of these facilities?
No.
Oh, so you didn't call 911?
So the police were, I was there waiting for the police to come.
Okay, so if it says in your statement that you called 911, that's untrue, correct?
No, I called 911. When I got to the site to tell the police I was there. That was the procedure I put in place. When I got called last night, they said, go to the site, when you get there, call 911. I called 911, and then the police show up.
Who called you to tell you that?
I don't have,
Did he give you his name and number?
it was, I think it was a,
I mean, after he gave you his name, you don't have to have his name.
it was the lady with the police department called.
I'm sorry?
A lady from the police department.
Okay. Why would they instruct you to call 911 and not the police station then?
I think that's a procedure they do. I have the same question, but that's a procedure they go through.
Okay. So you did not call 911 after you saw the three suspects fleeing and the pickup truck leave?
No, I called before that.
And the $30,000 to $33,000 amount of damage is just a guesstimate, correct?
Correct.
Were you there when either of the defendants in this case were located by the police?
No.
You had left already?
I understand they caught a nice.
You had left already?
One more time, I said, I got called in the morning that the two gentlemen understand were caught that night.
You were told that the two gentlemen left the building, or there were two people found in the building?
I was told that they found two people in the building.
Do you know what date that was?
Must have been the day they called it, it was a break.
Do you know what date that was?
No, what was it? The 8th?
Was it June 6th?
Whatever day they called me, maybe on the second, night before.
Excuse me for 1 second. 48 pages. Okay. So you were told by the police that they found two people in the building?
Correct.
Okay, and that was on June 6th, if they found this people, correct? Okay, but you got there the morning of June the 8th and saw three people.
Well, I got.
Excuse me, let me ask the question. After you got the call from the police, you got there the morning of June the 8th, correct? Yes or no?
I have no, excuse me 1 second, please.
No, yes or no? You got there the 8th.
I don't have my calendar in front of me. I got there the next day after the break, whatever day that was.
You don't know what day you were there? You don't have to make a log for the city of Detroit or a report?
No, I don't make a log everywhere unless I, obviously I could.
Okay, but the three suspects that you saw running out of the building and the dark blue pickup truck, that was after the two defendants were arrested, correct?
Correct.
Have those three suspects been found? And they had a truck, which implies that they were trying to make off with a load of stuff, correct?
I believe so.
Whereas at least my defendant, my client, Aaron Bateman, had no car or no truck at the scene, correct?
I have no idea.
Okay, I can verify that with the officer. So the black bag containing the power tools and a bag of strip copper, that was from suspects 1, 2, and 3.
I can't, I have no idea. There's left on the premises.
Mr. Primack advised me that the suspects left behind a black bag containing numerous hand power tools and a bag of shipped copper items. Is that suspect 1, 2, and 3?
I can't speak to who left them behind, so when I went to the site, I saw the bags were there.
But you called them the suspects, right?
True.
Did you surprise those suspects?
I believe so.
And then you said there was, that blue pickup truck was operated by suspect number 4.
True.
So all of those suspects, 1, 2, 3, and 4, 1, 2, and 3, fleeing the location or coming out of suspect 4, none of those were my client, Aaron Baker, correct?
That's what I understand.
Because he was already arrested.
Correct.
Okay, nothing further at this time, Judge.
Yeah.
Oh, yes.
So do you recall how you were notified about this initially?
Yeah, please call me.
Do you recall about what time of day that was?
It was night in the middle of the night. They give me, any break-ins, they give me a minimum, my phone numbers with the police department to break in.
Was it early morning at night? It was early morning. Do you recall approximately what time?
I probably around 6 o'clock in the morning.
6 a.m. So and that was June 6th.
So they had the break, they had the break after the work.
And you testified that you went to the scene on the 8th.
Whatever the day after the break was there.
Did you give your statement on the same day that you went to the location?
Yes.
On the same day? Correct. So if your statement was taken on June 8th, that would be the same day you arrived at the location.
What I'm saying is that
It's a yes or no question, sir. Did you give your statement on the same day that you went to check the place out?
Yes.
During your direct testimony, you indicated that the cost of decommissioning one of these substations is approximately $30,000.
$40,000 for it.
That's just a decommissioning,
Correct.
coming from no damages, just
Correct.
decommissioning. And the substation was slated for decommissioning.
Correct.
Yes. So that 30 to 40,000 is part of your estimates of damages in this case.
Correct.
No further questions here.
I just wanted to clarify with the damages. You had said that part of the damages was cleaning up the oil that was spilled from the transformers. And is that your $30,000 to $33,000 estimate for just that cleaning?
Depends when we test the facility, test the transformers, and if there's any PCB oil in the facility, that's a bigger process. We can't test it yet, or didn't test it because it's still in the facility. So that's the biggest issue. If there's PCB spilled in the facility, then we have a major cleanup bill. Actually, my team will be there the next couple of days to review how much damage this oil is spilled there.
And if there, you discover that there is that there, how much would that cost?
Could be another $3,000 or $4,000 or more. As I got the drains or not.
What was the numbers? What numbers you said?
$3,000 or $4,000 more.
More than what?
The initial break-in, if there's PCB oils needed to the drains, then I have a bigger issue. If there, we have to test all the transformers, if there's PCB oil in the transformers or switchgear.
I'm asking in addition to what was the number you're saying? 3,000 or 4,000 plus.
Yeah, plus the 25,000. Ballpark.
25,000 is for what?
All the outside of the facility was broken into, all the doors, the copper being stole, transformers knocked over, all wiring.
That's my request.
Based off, yes, I asked additional questions, yes.
Yeah, I'm confused. So you said the building was slated to be decommissioned, correct? Which means it would be taken down, correct?
No, you have the,
Out of use.
yes, correct.
And then you said that initially that the damage was 15,000 plus perhaps 3,000 or 4,000 if there was PCB and then disposal of it. Not 25,000, 15,000.
Plus the exterior of the building, all the, was actually destroyed, the outside, the locking mechanism.
You have no idea what the actual cost of that is, correct?
I said it was a ballpark estimate. We've done these in the past, and that's what the.
So right now, you do know that there's approximately $18,000 or $19,000 worth of damage. And then a ballpark guesses everything else.
Correct.
Nothing further, Judge.
So when you're estimating the damage to the broken doors and things like that, that's based on other facilities that would have the damage in that.
Correct.
And each facility, are they made exactly the same? Is the footprint of the building the same? Same doors, same layout, same floor plan?
Some bigger, some smaller.
Some bigger, some smaller. Is this one of the bigger ones or smaller ones?
Smaller ones.
This is one of the smaller ones, so it would have different doors than the ones on the bigger ones.
Yes.
And some of them do have different locking mechanisms.
No. Same lock.
What, same lock? And what kind of lock is this?
We have, I don't know the make of the lock, but it's basically I have a green key at all my substations.
Okay, and how much does the make a lock cost?
These are not
I
like.
don't know the make, I'm sorry, I didn't hear, I thought it was the make.
No, I don't have a make of the lock. I'm not locks with them.
Okay, and how much was the cost of the locking mechanism on one of the prior ones we had to replace? The cost of the lock itself, how much is that cost?
I have no idea. I had budget inventory, I'm not too sure.
And so you're really just guessing.
Well, I'm just talking about, to behind the building, all these transformers and facilities basically have big metal screen doors in the back to reduce the heat and transformers are going. The big metal doors were cut.
And as you sit here today, you testified, redirect, recross, the transformers were knocked over and things like that.
Correct.
What was the last question? The transformers were down what?
Were knocked over, kicked over. And you don't know who did that or when exactly that happened.
I can't speak to.
It's a yes or no question.
No, sir.
No further questions, Your Honor. Thank you.
This is case 2260773, the people of the state of Michigan versus Terry Waterford. Mr. Waterford is charged with one count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Set for an exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, may I please this most honorable court, Rena Mitchell is here on behalf of Mr. Terry Waterford. Your Honor, Mr. Waterford is not present today due to Macomb County not sending him over, so we're asking for an adjournment.
Okay, and I do have here that Madam Clerk did send a writ, so we will do it again and make sure it's confirmed. And get on the phone with somebody from Macomb County Jail to make sure that we picked the date of July 25th at 10 o'clock. Does that work?
That works for me, Your Honor.
Okay, hopefully we will be here on the 25th and we'll try to see you. Thank you. You're welcome. Have the rest of your day.
Thank you.
And Davion Brown, is that gonna be a hold?
No, certainly is, Judge.
Okay, all right, let's go back to Mr. Batman and Bowden. Ready to go for your next witness, Mr. Kirker?
Yes, at this time, the people call Officer Charles Porter.
You said Porter, right?
Yes.
Porter, stand state your name too.
Make sure you speak up.
Good morning. Could you please restate your name for the record?
Officer Charles Porter.
And Officer Porter, are you currently employed, and if so, in what capacity?
I am employed with the Detroit Police Department.
And how long have you been employed with the Detroit Police Department?
1 year, 2 months.
And were you employed in this capacity on June 8th, 2023?
Yes.
Did you in fact work on that date?
Yes.
Were you by yourself or with a partner?
With a partner.
What is your partner's name?
Officer DePaula.
And did your duties as a police officer take you to an area at or near 1373 Maple Street
Yes.
in the city of Detroit, county of Wayne?
Yes.
And what brought you to that area?
There was a call for a burglary.
And did you respond to that call?
Yes, we were assisting officers.
And did you make that scene?
Yes.
What happened when you made that scene?
We made the scene, we observed an open door. We then made entry with primary scout.
And where was this open door located?
It was on the front of the building.
And upon making entry to the building, what did you observe?
I observed several tools on the ground.
Did you describe those tools?
It looked like a full tool set with my sockets and ratchets.
And did they appear to be being used by employees of the building? Why?
Judge, I'm gonna object. That's a leading question. I don't know how we would know what tools are being used by what employees.
Also want to join the objection, but due to lack of knowledge, unless he observed what tools are being used for, was there in the past, unless with the report, he has no personal knowledge on which to base what these tools were being used for, who would be using.
I think it's speculation. To say who it's used for. Can you clarify?
I can rephrase the question. Where were these tools located?
They were scattered all throughout the floor.
They weren't like put away or anything.
And upon seeing these scattered tools, what did you do?
We continued searching the building, looking for anybody to.
And were you able to locate anybody inside the building?
Yes.
And how many individuals did you locate inside the building?
2.
Who was the first individual that you located inside the building?
Stephen Moulton.
That individual present in the courtroom today?
Yes.
Would you please point out the individual and identify what clothing they were wearing?
It's a gentleman in the green shirt.
Your Honor, let the record reflect the identification of defendant number 2.
I'm going to object because the gentleman wearing the green shirt is not my client. He just identified the other co-defendant as being Mr. Moulton. Mr. Moulton, please stand for the court. He's wearing a gray striped shirt, gray stripes on white. And the other individual stands, sir, please. He is wearing a green shirt, as was identified by the witness. So I object to the identification at this time of Mr. Moulton.
They have identified themselves.
To the court, Your Honor, but to this.
Yes, that's what I know for a fact, what you're saying is true. Mr. Attorney, do you have a response to that? Okay, so that is a inaccurate identification based on what you're saying is Mr. Moulton. Sure.
The gentleman who you identified, was he present in the building?
Yes.
And where was he located?
He was attempting to get out one of the front doors.
And was this individual detained?
Yes.
And were any other individuals located in the building?
Yes.
And where was that individual located?
The other individual was found hiding in the corner.
And was that individual detained?
Yes.
Was that individual detained? And was anything recovered from either individual?
On searching Mr. Batman, I believe, a socket was found in his pocket.
Was this the second individual?
Yes.
I don't think further, Your Honor.
I'm Warren Ellis Reporter. My name is Rosemary Deer. I represent defendant Aaron Chapman. So, in your report, you indicate that you and your partner, and I will probably pronounce your partner's name wrong, Dr. Lala?
Lala.
Okay. Made a run at approximately 2:50 a.m. on June 6th.
6. It was June 8th.
So if your type report says June 6th, that's a typo.
Yes.
And which makes sense because it says Thursday and June 6th was a Tuesday. When you say you observed an open door, what did the door look like?
It was I believe the door was brown, just a steel door. Didn't have a window on it, and it was open.
No screen?
I don't remember this.
And this door, was it similar to like a door like that?
Yes.
So
Can you identify the door?
yeah, similar to the door between the courtroom and the lockup or the front door of the courtroom.
It's like a steel door.
Had a handle on it
Yes.
or a doorknob?
I can't.
Was the door forced open?
It appeared forced open.
How did it appear forced open?
It seemed like it had some pry marks on it, if I remember correctly.
Okay, but you are just speculating, you have no idea if it was wide open.
Yes, I can't remember exactly.
Or in fact, the custodian of that building, Mr. Carnac, could have opened that door with his key, correct?
Very well could.
Was he there when you arrived at the scene?
No.
And this was at approximately 2:50 a.m.
Yes.
Upon discovering Mr. Pateman, he was immediately placed in handcuffs.
Yes.
Was that for a suspected DUI?
For suspected being.
But there was nothing indicating that he had participated in the B&E at that time, correct?
He was just in the building at the time.
And you indicated that you found a socket in his, where was that?
His, I believe it was front right pocket.
It was actually a socket tool bit, correct? It was a tool bit, it wasn't a wrench, it wasn't a full socket, it was just a small socket tool bit.
Socket.
What else did you find in the socket?
I believe he had his ID on him. He said he left his cell phone.
Chore boy?
Sorry, what?
Was there chore boy in his pocket?
I don't.
You don't remember? You don't remember discarding it? What about the crack pipe?
Yes, he had that.
What did you do with that?
That was discovered.
It was not placed onto evidence.
It was just discovered.
And at the time, he in fact told you that he had popped into the building while waiting for the bus to money after smoke crack, didn't he?
No, he stated that he was in there just trying to sleep.
What?
Sleep.
This was when your body cam was on?
Yes.
You say anything else?
Not that I remember.
Okay, and then Mr. Bateman did not own a vehicle, correct?
Correct.
No vehicle was towed from the scene.
No.
So for argument's sake, only implying that he was there for B&E, he did not have a vehicle to put things in to remove transformers or large pieces of copper from the building, correct?
Correct.
And how is the socket tool bit designed for cutting or burning or breaking open a building?
It's not.
So Mr. Patton did not have burglar tools in his possession, correct?
No.
That's not correct, or that is correct?
I guess it's not correct.
Why?
Well, you wouldn't use a socket to pry open a door, but you could use it to dismantle stuff inside the building.
Like what?
Anything that would require a socket, if there's any pieces of equipment that have any nuts on it, then it can be removed.
Can you show me with your hand how big the socket bit was that he had?
Maybe about that long, diameter about that.
So you're, I think the judge was trying to see as well, about an inch.
1 inch long and then diameter.
What kinds of things in that building would have nuts on them?
There was like fencing, there's.
You didn't have a vehicle to remove fencing, did you?
No.
Okay. And just to try and clarify the testimony here today, was Mr. Patman allegedly found by you hiding in the corner before or after Mr. Primack saw the 4 suspects running out of the building, getting into a pickup truck?
I don't recall 4 suspects running the pickup truck.
Do you recall Mr. Primack indicating that when he arrived on the scene, he saw 3 individuals running out of the building and a 4th driving a pickup truck?
No.
You never bothered to give you that information?
I never got it.
Oh, okay, who did you talk to them?
I'm not sure.
So you weren't aware of the fact that there were other individuals in the building who jumped into a pickup truck? So despite the fact that my client told you he was there trying to catch a nap, you just assumed or presumed that he was there to burglarize the building?
Yeah.
But there was no parts of the building found in his pockets or otherwise. And he had no car to leave the scene with, correct?
Right.
Do you know where Mr. Patman was living at the time?
We stayed with his mother.
What town was that in?
I don't remember.
What did we have in Aliyah? Is there a bus stop outside of that building?
I'm not sure.
There might have been.
Possibly.
I have nothing further, Judge.
When you went into the building, was it quantity of oil spread out on the floor that you made it slow down?
Not that I remember.
You didn't see any oil.
No, not that
You see any cutting torches?
don't remember.
And you've already testified to everything, right? No further questions here.
I have nothing further. Yeah.
Yes, Your Honor, one more.
Yeah.
No, that's okay. I was wondering.
They're gonna have to wait. switch over to the people of the state of Michigan versus Davion Brown. 2357540. Mr. Brown is charged with count 1, robbery armed, count 2, robbery armed, count 3 and 4, weapons of firearms set for exam today at 11 o'clock.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. My name is Daniel Wazak. My bar number is P35225. I stand with Mr. Davion Brown to my right. He is currently in custody.
Mr. Brown, can you state your full name for the record, please?
Davion Brown.
Are the people ready to proceed with this case?
People are not, Your Honor, the complaining witness apparently is moved and is unable to be notified of this exam.
Given that representation, Judge, I am making a motion to dismiss all charges.
We're not ready to proceed today. I will be dismissing without prejudice in the event that the claimant witness is found and wishes to prosecute. People can reissue this matter, but at this time, Mr. Bryan, case is dismissed. Anything else from either party?
Nothing else, Judge.
Nothing from the table.
How do you fill out the form? Fill out the form, it shouldn't take long.
This time the people call Officer Ryan Harris. Officer here. Sorry.
Please make sure you speak up in the microphone, that's fine. You know, you ready, Mr. President?
Morning. Please restate your name for the record.
Officer Brian Harris.
And officer, currently employed in Minnesota, what capacity?
Police officer with the Detroit Police Department.
And how long have you been employed as a police officer?
3 years.
And were you employed in this capacity on June 8, 2023?
Yes, sir.
Did you in fact work on that date?
Yes, sir.
Were you by yourself or with a partner?
I have a partner. Officer Snell Bond.
And did your duties as a police officer take you to an area at or near 1373 Maple Street?
Yes, sir.
Then in the city of Detroit, county of Wayne?
Yes, sir.
And what brought you to that area?
We were dispatched to that location on a breaking and entering police run.
And did you make that scene?
Yes, sir.
And what did you do upon your arrival at that location?
We made the location, observed the exterior, the front door was open.
And did you make entry into the building?
Yes, sir.
Did you clear the building?
Yes, sir.
Were there any individuals who were found inside that building?
Yes, sir.
Did you recognize those individuals when you saw them?
Yes, sir.
Individuals present in the courtroom today?
Yes, sir.
And who was the first individual that you came into contact with on that day?
Mr. Moulton, I believe.
Could you please point out Mr. Owen and identify article of clothing that you're wearing?
Bad, but maybe the gentleman right here in the white shirt.
Hunter, let the record reflect your identification of the
Going
defendant
to
referred
check
to.
to the identification. Hunter said his memory's not good. I mean, that's not possible.
Can you repeat that for the record?
Oh, I'm objecting to the identification because he said that maybe, and his memory is not quite good. So I'm going to object to that being an identification. But just for the sake of objection, I'm trying to understand.
Mr. Becker, do you have a response?
He has made those statements, I believe that would go to the strength of the identification.
Yes, he believed to be that person, so I will, it'll be reflected, he identified who he believes to be Mr. Moe.
And where was Mr. Moe located inside the building?
At the south end of the building, next to a barricaded door.
And was anything recovered from Mr. Moe? Or in the area that Mr. Moe was located?
Yes, sir. In the area where he was standing, I recovered a wrench as well as a glove.
You said a wrench and what?
A glove.
And when you say immediate area, how close is Mr. Moe to one of these items?
Right next to his foot.
So within reaching distance?
Yes, sir.
And you said there was another individual present in the building?
Yes, sir.
Was that individual detained?
Yes, sir, to my knowledge.
Did you come into contact with that individual?
I observed him, but I didn't take him.
You observed him?
Yes, sir.
Is that individual present in the courtroom today?
Yes, sir.
Could you please point out that individual wearing what clothing they're wearing?
I believe he's to the left of the other gentleman wearing a green jumpsuit.
And say to the left, you were left.
To my left, yes, sir.
Now let the record reflect the identification of defendant number 2.
So requested.
Apologies, Your Honor. Defendant number 1.
Yes, they're switched, lines are switched with. Reversed. Correct.
Aaron Bateman's defendant 1.
And did you make any other recoveries while on the scene?
No, sir.
I have no further questions.
Good morning, Officer Harris.
Good morning.
Who called in the V&A policeman?
We're dispatched to that run.
Do you know if someone called that alleged V&E in?
I just know we were dispatched.
You said you were dispatched on a V&A policeman.
Yes, ma'am.
That's what the dispatcher told you?
Yes, ma'am.
Okay. And did you ever have any interaction with the superintendent or the caretaker of the building, Mr. Carmack?
No, ma'am.
You never saw him?
No.
Did you detain Mr. Eric Patman, my client?
I did not.
Did any of the officers convey to you that there had been 3 individuals who fled the scene and left in a Ford pickup truck?
No, ma'am, I don't recall hearing that.
Mr. Carmack did not tell you if you observed that when you got there?
Can you repeat the question?
Mr. Carmack did not tell you that he observed that when you got there?
I didn't come in contact with Mr. Carmack.
Okay, so you didn't know about the other individuals that were seen by Mr. Carmack fleeing the building, correct?
Correct.
And getting into a truck and taking off.
Correct.
The 4 suspects, as they're called, in all the other police reports except for yours. So you don't know if this dispatch was regarding these 4 suspects, 3 who were found in the building, and the 4th running outside of the truck, and the 3 eventually left it.
As I stated, I don't recall hearing anything about other individuals in the truck.
No, I said, you don't know if that's what the B&E police run was. It could have been that, correct?
Possibly.
Mr. Patman and Mr. Wilton just being, or at least Mr. Patman, I won't speak for Mr. Wilton. Collateral damage just happening to be in that building for whatever reason.
Those are your words.
Well, how could you possibly not know about the other 3 people who were seen fleeing the building into a truck, and that there were 4 other suspects if you're part of this case as a reporting officer?
Yes, ma'am. I wasn't made aware of 4 other officers.
No, not officers, 4 other suspects.
4 other suspects.
So you didn't discuss this case or the case details with any of the other arresting officers?
It wasn't conveyed to me in the case details. I did discuss the case as well as the details. I wasn't privy to that part.
What it was, all the other officers were privy to that, it's in their reports.
I never heard that, but again. if that's
Well, I'm not
just-
making it up, I'm reading from the report of Ida Sexton. And also, looks like Officer Porter.
Officer Sexton wasn't there the night in question.
Then why would he make a report indicating that he was there?
Your guess is as good as mine, man.
I'm sorry?
I said your guess is as good as mine.
Reporting that he responded to the scene and met with Mr. Primack, stating there was a break earlier in the night, he was responding to assess the damage.
What was the question?
I don't even remember. I'm good, Judge. I think no more questions for this officer. Thank you.
Officer, when you wrote this up, well, let me strike that. Your initial assessment of both these defendants were that they were homeless, you can see, correct?
That's what I was told. That wasn't my initial assessment.
Why did you put it in your report, homeless?
That's what I was told.
What's he say? Told.
And what time did you respond to the scene?
I don't recall exactly.
Without taking a look at your report, help refresh your recollection.
Yes, sir.
Your Officer Harris.
Yes, sir.
Commissioner Prochron.
Yes.
Okay.
Do you recall now, sir?
Yes, sir.
And what time was that?
2:49 a.m.
And how long did you remain at the scene?
I'm not exactly sure. Possibly an hour or so.
And Mr. Primack never arrived at the scene while you were there.
I didn't make contact with Mr. Primack that night.
Did he show up while you were there?
It's possible. I didn't make contact with him. No.
Were any other officers at the scene when you were at the scene?
Yes, sir.
Who else?
Other scouts, not sure their names, but other officers were there.
No further questions, Your Honor.
Direct.
Nothing further, Your Honor.
Thank you. Any other witnesses?
No other witnesses from the case.
Any defense witnesses?
Yes, Your Honor. The defense will call Officer Adam Sexton, badge number 3114.
Got it.
Your Honor, the police support in lieu of calling this witness and getting an adjournment, I believe people are willing to stipulate to one fact that Officer Sexton had met with the complainant, Mr. Primack, at 11 p.m. on Thursday, or 11 a.m., not p.m., 11 a.m. in the morning on June 8th, 2023 at the location. Thank you, ma'am. That was the only purpose for that witness. This is establish the time.
And Mr. Kirkland, everybody's argument.
Just some of the people move to bind over defendants 1 and 2 on count 1, breaking, entering, building of intents. Defendants 1 and 2 on count 2, malicious destruction of the building, $20,000 or more. And defendants 2, not defendant 1, on count 3, burglars, tools, possession. As we heard from the director of operations of the building, John Primack, he gave the location of the building in the morning of June 8th. Building is located at 1373 Maple Street. It is owned by the city of Detroit. To clarify, it is a Detroit lighting substation. As he testified to, the last day that he was there was the day prior to this break-in. He was the one who locked and secured the building. At this time, he did not observe any damages from inside and outside the building. He was the last one to lock up the building, and he was the only one who had access to that building. When he made the scene on the morning of June 8th, he observed damage to the exterior rear door, which he had testified to was one of the doors that he had locked before leaving the previous day. Since the building was to be decommissioned, the main damage was oil spill from the transformers being tipped over. There was some confusion as to the damages. However, in response to your Honor's question, the witness clarified $25,000 in damages were compared to the outside of the building, the inside transformers that were knocked over, the oil spills, the copper taken, and then a possible $3,000 to $4,000 more damages if it tests positive, the oil tests positive for PCP. Officers then testified to making the scene of the break-in around 2:49 a.m. on June 8th. On making entry into the building, Officer Harris identified both defendants. Only officer had observed defendant number 1 be detained. He did detain defendant number 2, Stephen Bowden. On detaining defendant number 2, he observed a wrench, which was located, and the black glove, which were both located at the feet of defendant number 2. People believing that the person of probable cause was notified of these things.
Would like to go first? First of all, Mr. Carnac never clarified there was $25,000 worth of damage. He admitted that was a guesstimate, and all he could allegedly clarify was $15,000 worth of damage plus $3,000 to $4,000 in additional damage for a total of $19,000, thereby negating count 2. Judge, there is absolutely no evidence that Mr. Patman was the person who broke into the building. The door was open. Officer Harris testified that the 1 by 2 inch socket bit that he had on him could not open the door. At most, it was an entering the owner's permission on my client's behalf. I don't think he did not have a wrench in his possession, which is alleged in count 3. He had a socket bit, and the officer testified that could not cut, burn, force, break open the building. There was no intent shown to use the socket bit for that purpose. In fact, Mr. Patman, according to police officer, indicated that he just wanted a place to sleep. The officer indicated that he found a crack pipe on Mr. Patman and disposed of it, were his exact words. I don't think there's been probable cause to show count 1, count 2, or count 3 in regard to Mr. Patman. At the very most, it's an EWAP and entering without owner's permission. And interestingly, Mr. Primack testified that when he got there, 3 individuals ran out of the building, left behind a bag of tools, a black leather bag of tools, and there was a 4th person who was circling the building in a pickup truck that is listed as suspect 4 in the police report, 1, 2, and 3 being the 3 people who ran out of the building when Mr. Primack got there. So in regard to Mr. Patman, Judge, I would ask that the court dismiss these 3 charges against him. This falls very short from showing intent to steal any malicious, willful, or malicious, or injury of the building or purpose by Mr. Patman whatsoever. And I do not believe that it's not 1 inch socket bit. It's not a wrench, and I don't believe that would have, even if it opened a nut, as Officer Harris stated, to remove a big screen. Officer Harris stated that Mr. Patman had no car, no way to transport anything. There were no bags near him on the ground. There was a crack pipe though, which disappeared and was not put into evidence. I would ask that the court dismiss these charges against Mr. Patman.
Thank you, Your Honor. Your Honor, as to Mr. Moulton, all those records established that approximately 3 a.m., Mr. Moulton was arrested while leaving the building. And that there was one glove and a wrench not found in his possession, not that he was seen to have been throwing them down or anything, but in the area where he was found. That's it. The evidence that did come out was that, and thanks to the stipulation, we established the 11 o'clock p.m. time or a.m. time when the witness had observed these damages just after seeing 3 other individuals exit the building and make a run for it, and some trucks circling around. My memory of this testimony is a truck circling around. They left somebody inside. I also recall that he testified something about a torch being used to cut open the bottom of the transformer to let oil out and everything. But officers never covered any cutting torches or anything. My point is, so all they did was show up at the scene and find 2 men inside. Lord knows what they were doing. One of them had a socket piece in his pocket, maybe something picked up. Speculation that the socket piece, a socket bit, is not a burglary tool. Burglary tool is specifically defined in the statute as to what it is. Cutting or burning through, forcing or breaking open a building, room, wall, safe, or other depository in order to steal their food. A socket bit can't do anything on its own. You can maybe throw it at someone, but there's no way to use it. But that's not even my defendant. Mr. Moulton wasn't found in possession of anything. And again, the officer didn't tell. Neither one of these arresting officers showed up at the scene and testified to any damages other than they think the back door was pried open. No wire laying around anywhere, no things being scrapped, being stacked up to be loaded, nothing. They just arrested these 2 gentlemen and took them out of there. If those things had happened prior to those responding officers arriving, they would have testified to it. And we didn't hear any testimony from that. What we do have before the court is a gentleman who shows up at 11 a.m., hours and hours after, sees the actual perpetrators leave the building, and then just wants someone to pay. So they can't even identify these as being the individuals that caused that damage. All we've got before the court right now, as it sits, is trespass. And I request the court not find these charges over or just dismiss the whole case without prejudice, because if these guys are right, they should be able to come in with some evidence. I would hate to see a true victim get outlawyered, so to speak, but dismissal without prejudice does no harm. And if these are the right people, they can identify them as being probably the individuals that made these damages. Right now, we have every indication that they're not the ones that did this. I respectfully request that the case not be found over and that it either be amended to misdemeanor trespass or just dismissed without prejudice and let them get some evidence to put before the court to base this on.
Address count 3 further rule.
Yes, Your Honor, and that's why when I was began arguing that stated that edit number 2, I believe it was a charging error. Says Officer Harris testified to the wrench was found at the feet of defendant number 2, Stephen Moulton, as well as the glove. And as he testified to the reach of defendant number 2.
Objection, Your Honor. No one said it's in the reach in the area where he was found.
I have the testimony that by his right foot. Right next to right foot. That's what I wrote down. That's right. Would you agree with that?
I do remember asking him, was this within the reach of these evidence, and he responded, yes.
I think the court's memory, I didn't recall saying anything about within reach.
Well, if it's by his foot, it's within reach. I do have it in right here.
And so, just to clarify, count 3 would be for defendant number 2, not defendant number 1. As to other arguments, the defendants were located in this building by officers around 3 a.m. at night. Testified to arriving on the scene to the front door. Opens. As the complaining witness testified to, he was the last person to lock and secure that building. Nobody else had access to that building. He did not make the scene until 11 a.m. the next day. So both defendants were found located within the building. One was found with a wrench and glove by his foot. So the vehicle was again certain probable causes, and that's the crime.
Okay, with the correction for count 3, I'll start with count 3. To remove defendant 1 and add defendant 2, I do believe people have met its burden of proof for burglary tool possession. As we all know, possession does not have to mean that it's in the person's hand or on somebody's person. There's also constructive possession. That's knowledge with the ability to control. I believe in this case, number 2, Mr. Moten didn't know that that wrench was next to him and had the ability to control it. Now, I'm not an expert with burglary tools. That would be a question of fact for the trier of fact, whether or not that wrench that was found by his foot was considered a burglary tool. To count 1, breaking and entering. And I'll start off actually talking about identification. That was going to be an issue, and through Officer Harris, he was able to identify both defendants. And Mr. Primack's testimony was actually very confusing for me. The numbers that he was providing, and he also stated they were guesstimates, and he was not responsive to several questions that were asked by both parties. I felt as if he wanted to be a lawyer today and not a witness. So I extracted what I could from his testimony. So for count 1, breaking and entering, people have to show the probable cause standard that the defendants broke into the building and they're both charged with this count. It requires force, but it does not require anything necessarily broken. Even an open door is enough to satisfy that element. So I do believe that element has been met. They had no permission to be there. There was a back door that was open as well as the front door through 2 different witnesses. Second, that the defendant entered the building. They were both found inside the building when the police arrived. Third, that when the defendants broke and entered the building, they had the intent to commit larceny. So here we have Police Officer Porter, who testified that there were several tools in the building, a full tool set, also sockets and ratchets scattered all over the floor. And the defendant 1 had a socket tool bit in his right pocket. Defendant 2 had a wrench plus glove next to his foot. We also have testimony from Mr. Primack that not only shows intent, but could be probable, this is probable cause standard, that the materials were actually stolen per Mr. Primack, who testified that he was present the day before and observed that no materials were taken for destruction to the building. And then once he arrived on the 8th, that there was damage done. So I believe the people at the probable cause standard has met the burden of proof for count 1. For count 2, malicious destruction of the building, people have to show 1, that the building belonged to someone else. Here in the city of Detroit, there was a lighting substation that did not belong to the defendants. 2, that the defendants destroyed or damaged that building or anything permanently attached to it. In this case, we have testimony that the transformer was knocked over, as well as back doors cut into through Mr. Primack. Once again, the testimony that he inspected the building the day before and that nothing was damaged in his last inspection. Officer Porter also testified that the back door appeared to be, or there appeared to be pry marks, but then he also stated that he was not sure, but did state that there appeared to be. Third, the defendant did this knowing that it was wrong and with the intent to damage or destroy the property based off of the transformer being knocked over, and the possible broken in prime marks, that element has been satisfied. And the issue here is with element number 4, that the extent of the damage was, in this case, $2,000 more. I don't believe that Mr. Primack established that a total of $20,000 plus the damages was done. As I stated before, he had very confusing testimonies. I do believe that there was $1,000 or more, but less than $20,000 in damage through the transformers and his estimate of what needs to be replaced. But during his testimony, he stated $20,000, then he stated in excess of $10,000, $15,000, and then said $30,000 to clean, but not yet determined because he didn't know whether or not he needed that. Then stated $23,000, $4,000 or more, and then $25,000 outside facility damages. Was stated that he would do an estimate tomorrow for an actual. So I do believe based off of the damages that element number 5 is only met at the $1,000 to $20,000, not the $20,000 mark. So with that, if the people wish to bind over on the lesser charge or the lesser amount, fine, otherwise this will be dismissed for count 2, because I don't believe $20,000 has been met. Mr. Kirker?
That's okay.
Okay. So for counts 1, 2, and 3, I will bind over the defendants with the correction. For count 2, it will be $1,000 to $20,000 instead of $20,000 or more. And for count 3, defendant number 1 will be removed and defendant number 2 will be added. So Mr. Patman and Mr. Moulton, you have been bound over to Third Circuit Court. Your arraignment on the information date will be 2 weeks from today. Today is the 10th, so that will be July 24th at 9:00 a.m. I don't know if it's in person or on Zoom, depending on who you get as a judge. Your lawyers will let you know. Is there anything else from either party?
Nothing.
You might want to talk to your lawyer before you speak. He has a question for you.
Yes, I will stand up in 1 second.
So actually, I'm correcting, since Mr. Mobley is in custody, it's a 1 week arraignment on the information. It'll be the
This is
17th.
Mr. Patman.
Right, so both will be arraigned in 1 week.
I'm not available next week. I'm going to have surgery, so.
I can't change that date. You have to contact the AOI judge.
Well, if it's okay with sister counsel and client, I can stand in for the arraignment and stand in and wait for reading the information since we.
What date is it, the 17th?
Yeah, I'd be happy to do the same. So,
That can be discussed off the record. I can't change the 17th.
Right, I'll call the courtroom and let them know. I had something scheduled in Frankfurt on that date, but I just adjourned because my surgeon said he didn't want me utilizing my hand driving or otherwise carrying anything for at least a week. So
Is your client want
I can maybe do it by Zoom now, I'm thinking.
Your client want to address the court?
I'm confused.
Count 3 is dismissed against you, so that's out. Count 1, unfortunately, breaking and entering with intent was somehow bound over. Count 2 was lower from malicious destruction of property over 20,000 to.
It wasn't somehow bound over. I believe the people had enough to bind it over based off the probable cause.
That I wrote in.
The 3 counts, they were read off, yes.
I'm sorry, Judge, I just didn't see any intent at all.
Okay.
The stop, don't say anything. The judge made her ruling. Count 1 was bound over his charge. Count 2 was lower to malicious destruction of property of 20,000 and 20,000. Not 20,000 and over, so lower to the time for that case. And as to count 3, that was dismissed.
It was not dismissed, it's actually Mr. Patman or Mr. Moulton.
Against Mr. Patman, it was dismissed.
Mr. Moulton.
This is Mr. Moulton.
Okay, that's why it's switched around. Mr. Moulton got it, and it's dismissed. Okay, because you all switched.
Or moved to Mr. Moulton, maybe not.
Okay.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
You're welcome.
See you tomorrow on Zoom early. I have a piece of the early.
Okay, you want to just set the date now so you can take care of your surgery? You have discovery?
I have paper discovery.
Okay, we're on the record, this is people of the state of Michigan versus Paul Rice, 2260363. Mr. Rice is charged on this case with count 1, attempted second-degree arson, count 2, arson, preparation to burn real property, count 3, arson of personal property, less than $200, which is a misdemeanor, with an habitual offender second offense notice. Mr. Rice is also charged on case 2260502 with count 1, second-degree arson, count 2, arson preparation to burn real property with an habitual offender second offense notice, both set for exam appearances.
Alexander Kirker on behalf of the vehicle P86282.
And good morning, good afternoon, the May Police Report, Sarah Robinson, P63181 for Mr. Paul Rice.
And Mr. Rice, can you state your full name for the record, please?
Paul Anthony Rice.
Okay, any preliminary matters before we begin?
None from the people, Your Honor.
Frustration.
Okay, there's anyone on Zoom or YouTube who may testify or is a witness on this case, now's your time to log off. Same in the courtroom, if there's anyone present who may testify or is a witness on this case, now is your time to exit the courtroom. Is there an officer in charge that?
There is, Your Honor, an asterisk exception for.
Objection?
For the OIC, no.
Okay, all right, you call your first witness. I guess I should figure out which case are you trying first?
I have just in for.
You have a seat, Mr. Rice.
I have 220606363. The one is the first case.
Like,
This time people call Thurston Rogers. Thurston.
You swear to tell the truth, what you did. Your oath is right here in front of you. Just make sure you speak up in the microphone when you respond. Whenever you're ready.
Good afternoon. Would you please restate your name for the record?
Thurston Rogers.
And I want to take you back to the date of June 20th, 2022. Do you remember that date?
Yes.
Were you at 97 8th Street?
Yes.
Is that in the city of Detroit, County of Wayne?
Yes.
And what is that location?
That's where I live, my home.
And did something happen that brings you into court today?
Yes, sir.
And what was that?
An incident occurred with, an individual on the right that attempted to set my house on
I'm
fire.
gonna object foundation, this calls for speculation.
Which part, the identification or the trying to set his house on fire?
That's the whole part, yes.
We can break it down.
Okay. Please let, provide some foundation to the answer. Right.
So Were you awake or were you asleep at this time?
I was asleep.
I'm gonna object here what time. I was just a testimony as to the date.
He said an incident. Can you clarify what it is?
Were you awake or asleep around the time of the incidents?
I was asleep. My doorbell was ringing.
Did your doorbell ring wake you up?
Yes.
And upon hearing your doorbell, what did you do?
I got up and went downstairs and counted the gentleman on my porch.
You encountered somebody on your porch?
Yes.
Did you recognize that individual?
Yes.
Is that individual present in the courtroom today?
All right.
Could you please point out that individual and identify the article of clothing they were wearing?
All right, green uniform.
Your Honor, let the record reflect the identification of the defendants. And you said the defendant was on your front porch at this time?
Yes.
And did you observe anything else at this time?
I was aware that he was ringing my doorbell to get me awake to come out.
I'm gonna object here cause for speculation as to what my client's intent was.
He was ringing the doorbell, is that correct?
Yes.
How, he was trying, what he was trying to do was the right, says he didn't know speculation. But. Or speculation, I'm sorry.
But the defendant was ringing your doorbell?
Yes, he was.
And what happened after you made contact with the defendants?
I actually made no contact with him at that time. I called, because I noticed what he was doing.
And how did you notice what he was doing?
I'm gonna
He
object.
was on my,
1 second.
We've had testimony that the witness encountered my client on the porch. Now he's saying he didn't encounter him. So where's the foundation for what he saw my client doing?
You can see somebody observe something without time. So I think the question needs to be asked next to what you saw. If it.
How did you see the defendants on the porch?
I observed it. I did not have contact or speak to him
And how did you observe that?
through my window.
And what did you observe the defendants doing?
He had a cigarette lighter in his hand. He was at the end of my porch striking his lighter, attempting to set something on fire.
And I'm gonna object cause for speculation that what he was attempting to do.
I will ask some more questions for that foundation. Okay. We'll clarify. So you saw him with a lighter in his hands, is that correct?
He was flicking a lighter, standing on my porch, next to my porch stand, the stand that holds my porch up, by the bottom of it.
Okay, and where was the lighter at this time?
In his hand.
Was the lighter on?
He was striking the light, yes, with fire coming from the lighter.
And how close was this to the porch?
Right on the porch. He was on the porch, in the corner by the pole, striking the lighter.
And were the flames of the lighter making contact with the porch?
Yes.
And did the porch catch on fire?
No, it did not. Everything around it is like covered and something that will not cause a fire.
And did the defendant remain on the porch at this point?
He stayed on the porch. He came back and rang the doorbell. He went back to the corner. He looked over to try to see something. I don't know what. He came back to the porch.
And so the defendant was on the edge of the porch?
Yes.
Looking out over the porch?
Yes.
Was this toward the streets?
Yes.
And what did the defendant do after
He walked off of the porch, down towards around the house where I had the American flag standing, and he lit the flag on fire.
And you were still observing this through the.
Yes.
And that's a leading question, objection.
That he was still standing there?
That he's still looking through his window.
I can rephrase just to clarify. When you said you observed this, how did you observe it? The defendant light the American flag.
Standing at my window looking out at it.
Was this the first floor, second floor window?
First floor.
And did the flag catch on fire?
Yes, it did.
And what did you do at this point?
I called police, came out, observed the damage that had been caused.
And what damage had been caused?
The flag was burnt.
Was there any other damage?
It's basically the flag burned up.
Was there any damage to the pole the flag was attached to?
Yes, the pole was touched. It did not burn up.
I do have video to play in this case. None of the issues with showing it on the screen. But as the defense counsel wouldn't mind if I would just show it on my laptop to the witness.
I mean, I'm objecting, if you're trying to put in evidence, I'm objecting. Foundation, authenticity.
Well, I'm still gonna get to that, so as far as logistics, like.
No, I don't mind, no, okay.
Starting at second 0, I'll just play a few seconds of this video for identification purposes. And for the record, I have stopped the video at 5 seconds. Now, do you recognize this video?
Yes.
And how do you recognize this video?
This is in front of my house.
Did you watch this video?
Yes.
When did you watch this video?
Sometime after the occasion, after the incident occurred, I saw it. The police, the fire department trying to put the flag out. The police came out later to investigate and see the damage that was caused. And I explained to them what had happened that I saw and showed them the video because the camera that the picture was taken from is mounted on my front porch, and it took the picture of what happened.
And now, does this video appear to be in substantially the same condition as when you viewed it?
Yes.
Do there appear to have been any material alterations or deletions?
No.
And at this time, the people have moved to admit the videos, people's proposed exhibit 1.
And I'm gonna object to its admission. Due to authenticity, I do not believe the client has personal knowledge, and that will come out in cross-examination as to the things on that video.
You said the client didn't have personal
No.
knowledge. Your client?
No, I'm sorry, excuse me, it's been a long day. The witness doesn't have personal knowledge.
Of the video he's claiming to be his on his own.
Correct.
His video on YouTube.
Correct.
Okay, so because, like you said, because I don't have that, based on what he's testifying to, saying that it's his video on his record.
But I'm gonna say he doesn't have personal knowledge of, I contest that he has personal knowledge of what happened on that porch.
As far as the authenticity of the video,
Right.
if it's from his doorbell or his ring, I don't know what type of service it is, if he's saying that that's his video, he can authenticate to it.
But I'm saying that he didn't witness the event. That's my contention. He did not firsthand witness the event.
Okay. Well, I'm going to allow it to be entered as he's testifying that he's testified so far that he saw the defendant. Then as far as striking a lighter, he on the porch and lighting somebody. And of course, on cross, you can question.
And Your Honor, just for the record, skipping ahead a few seconds to 14 seconds, and I intend to play the video through the, it's 2 minutes until.
Okay, I'm going to stand behind you, sir. Watch it.
Video stopped for the record at 2 minutes, 0 seconds. We're an individual that you recognize in this video.
Yes.
And who is that individual?
All right.
And I want to direct your attention to the right side of the screen. What is located on the front yard?
American flag.
All right, no further questions.
Mr. Rogers, at your home, is your bedroom upstairs or downstairs?
Upstairs.
All right. And you indicated that you thought you heard the doorbell and woke you up,
Yes.
so you were looking out from your bedroom window?
To start off, yes.
Okay. And can you see your porch from your bedroom window upstairs?
Yes, sir.
You can?
Yes.
All right. And you can see down onto your porch?
I can see down to the top of my porch. I can't see the underlying of the porch. I came downstairs.
No, hold on, sir.
I'm sorry.
So the top of your porch is covered,
Yes.
there's a roof on it.
Yes,
So if you're looking out of your bedroom window, you wouldn't be able to see anybody standing
No.
on the porch. Okay, so you wouldn't be able to see that, right?
I would not.
Okay, and, all right, and then you were asleep, weren't you?
When the doorbell rang, yes.
Okay, and then you, did you hear it again after that?
Yes.
Or so some time went and you heard it again?
Yes.
All right, and you looked out a window, you wouldn't be able to see anything on the porch at that time, right, from the bedroom?
I came downstairs, answered the door.
No, I'm just asking.
From the bedroom upstairs, no.
Okay, all right, and then you got dressed before you came out?
No, I did not.
You did not get dressed?
No.
Okay. All right, and then did you check your cameras before you wanted to look out the window? Or
No.
something? You didn't? Okay. All right. And then you went downstairs and peeked out the window?
Yes.
And so let me get this right. You heard a doorbell. And you heard it again. And you came down the stairs and then you looked out the window.
Yes.
You have a large house, don't you?
In a big house.
All right. And you have a big staircase that
I
comes
got a
down?
staircase that comes down.
And how long does it take you to get down your staircase?
Just a few seconds when I hear the doorbell ring that time of night.
Just
I
a few
rushed
seconds?
downstairs to see who was at my door.
You're rushing down the stairs in a few seconds in the middle of the night?
Yes.
Okay. All right. Now, did you call the police right then?
No.
All right. When you looked outside, did you see anybody?
When I looked outside, I saw Paul Rice.
Okay. And then when you saw him, did you call the police right
I
then?
called the fire department, I called the police, and all of that.
Right then?
Yes.
Okay, so when you first saw him on the porch is when you called?
Yes.
Okay. All right. All right. So do you remember making a statement to the police, a written statement on June 23rd, 2022?
Yes.
Okay. And do you remember, indicating that you got dressed before you came downstairs?
I don't remember that.
Can I approach with your statement?
Sure.
Have you refreshed your, sir?
Right.
Have you refreshed your memory?
I'm reading.
Yes, sir.
That's my statement.
All right, so you were able to determine that you got dressed first? You told the police at that time that you got dressed first, right?
Yes.
And you also told the police that you checked your cameras before you checked any.
Verbatim, I do not remember exactly what happened. I know what happened. I made the statement and that's what happened.
All right, and this statement was made in on June 23rd, 2022, which was right at the time of the incident, right, the very next day?
Yes.
Okay, so at that time, you indicated that you got dressed and then checked your cameras and saw nothing at the time, is that right?
I don't recall that.
Okay, well, here, I'll give you your.
You can show me that until next week. I don't recall saying that. I'm
Okay.
telling you what I can recall.
Is that your signature? at the
Yes, it
bottom?
is.
All right, and on this statement, you know, Your Honor, I'd like to move for admission of this statement if he doesn't recall what he wrote or he's contesting that that's what he signed. I'd like.
I'm not contesting that. I'm
Okay.
contesting that I do not
Sorry.
remember. I'm sorry.
It's
I'm
okay.
sorry.
You said you would like to hear based on what? He's saying that that's not what he said, or he's contesting that this is what he said at that time. I'd like to move for this statement into evidence.
Not the way it was contesting what he said, is simply saying he doesn't remember verbatim what he said.
Yeah, I'm not gonna allow it based off of him saying, he said he can read it however long he wants to, he's not gonna remember saying what he recalls saying versus what the statement says.
All right, and then on this statement that you, one day after the incident, you indicated that you went outside and saw smoke and then called the fire department. Is that right?
That's what the statement said, yes.
Would you like to see it?
No.
All right, and that the first thing you saw was a flag on the ground smoldering, or smothering is what you were, smothering on the ground, right? Is that correct, sir?
Okay, yes.
All right, so you actually didn't see Mr. Rice on the porch with your own eyes, did you?
I came downstairs and looked out, I did see. I don't, if you're asking me to tell you exactly what happened at that particular time, it's virtually impossible. I'm telling you what happened as I remember right at this moment.
Okay.
I understand what you're about to say, and yes, that is on.
All right, and so you reported to the police the very next day that the first thing you saw was a flag smothering on the ground, United States flag smothering on the ground. Okay, and then you also reported that you went back and watched video, correct?
And for the record, are you showing him the statement to
I'm
refresh
showing,
the recollection?
yes, Your Honor, I am, thank you. It's page 2 of his statement. So it's actually what you saw in the video is what you.
Correct.
It wasn't looking through the
Correct.
window. Okay.
Correct.
Any other questions? You're right.
Just want to clarify this on the cross. So you observed the video from this incident, correct?
Yes.
The night of the incident?
Yes.
And as you testified to, you saw an individual in that video?
Yes.
Did you know this individual?
Yes.
And you've identified that individual as the defendant?
Yes.
Judge, and I'm gonna remove my objection to that video going into evidence. This witness testified originally that he had personal knowledge and observed my client on his porch, which is not the case at all. He reviewed a video. I don't think the foundation is proper. I think it only can come in if he has personal knowledge.
I believe there has been a foundation. The witness testified to his video, to reviewing the video, to recognizing the video. There were no alterations or material deletions made.
Yeah, so I'm going to allow, he laid the foundation of this video and it hasn't been altered. On that date, he was at the house and he testified that the incident happened on his porch. So I will allow it, but I'm aware of what just happened as far as your cross and his statement that he only observed it was great as far as the incident happened. For the video, I'm not sure.
And I have nothing further.
Mr. Rogers, you're upset? Please step down. Any other witnesses?
No other witnesses from the people.
Any defense witnesses? No. Okay, we begin argument as soon as Mr. Rogers steps out.
And this time the people would move to find over the defendant on count 1, attempted second-degree arson, and count 2, arson, preparation to burn real property. As the complaining witness testified to, he was awoken at around 1 a.m. on on the night of June 8th, or apologies, June 20th, 2022. He was at his own home. I believe after cross-examination, we clarified the order of events, that he did get dressed, that he checked his cameras. Through the cameras, he was able to observe an individual who he identified as the defendants, Paul Rice. He observes, as he describes, the individual saw through the video is a lighter to light portions of the porch. The individual, the defendants, then exits the porch, and as the witness testified to, as you can see on the video, this flag is lit shortly after the defendants exits on the porch. People believe they have met the probable cause.
What I support not to find over as the flag that is applied to count 3, which is a misdemeanor, separate from the count 1 and count 2, which is second degree attempt, second degree arson, and count 2 arson, prep to burn real property. After cross-examination, I don't think there was a clarification. I think what came out is that the witness was not telling the truth. He fabricated his testimony. He did not see anything out of the window. He admitted that that was the case. As far as the attempt, second degree arson, there was no burning or charring of any part of his home. There was no testimony to that. There was no evidence put in by the people. As far as the second degree arson, they have to meet the attempt part. This is attempted second degree arson. And I'm not acknowledging that there was a preparation, but if there was a preparation, there's not enough that there were preparations made. There's not enough for an attempt. It has to go beyond mere preparation to the point where the crime would have been committed and not been interrupted. There's no evidence that there was any interruption there at all. As far as the prep to burn, there has to be evidence that there was a flammable or explosive substance placed near the property with intent to commit arson. There's been no showing that there was an intent to commit arson. And I am separating the dwelling from the flag. I'm not even talking about the flag which goes to the misdemeanor count. These are separate. There is no prep there. There was no accelerant laid on the porch. There was no wood laid on the porch. There was no preparation. So if there's no preparation, there cannot be an attempt. And even if there was preparation, that's not enough for the attempt second degree arson. So, Your Honor, I would ask the court to dismiss count 1 and count 2.
I do believe that there was an attempt here. As we saw from the video, the defendant is using the lighter to holding into portions of the porch. As the witness testified to his.
And I'm gonna object, that's facts not in evidence. That's the prosecutor's interpretation of what's on the video.
First, as far as Mr. The complainant witness not actually observing the incident.
Yes, Your Honor. I believe after we clarified between the two that the complaining witness had the order of events wrong, that he first observes the video, and that's where he observed the defendants on this porch, the actions that he testified to.
I just want to hear what you had to say about not actually seeing the whole incident.
And as to his porch, he did testify to the fact that it is covered in a substance that is not flammable, and that it would not have been, or that would not have caught on fire if just the flame was held to its. So we believe that there was enough of an attempt and that it was prevented from doing so by the substance that was as the witness testified to, was on his porch covering before preventing the defendant from doing so. Once again, asked it to
Mr. Carter, can you go through the, for arson, preparation to burn real property, can you insert the facts for those elements, please? Your argument for the count two.
the count two.
Yes.
Preparation to burn real property.
Yes.
And what we have is that the witness testified to seeing the defendants in the video, have the defendants using an object on the porch, and exits the porch, and as the witness testified to, that is where the flag was located, that was then set on fire. The video does show the flag, initial stages of the flag being set
And I
on fire.
believe that this count only pertains to the porch, not a flag. That's the count two.
That's, I want some clarification for count two.
Okay.
The jury instructions, maybe I can just actually.
On the
ask that.
information, it says porch.
I'm just relating a flag to the porch that the defendant was on the porch using this item and exits the porch, uses the same item on the flag. But the flag lights on fire, but the porch does not light on fire. As the witness testified to the reasons for why the porch did not light on fire.
Right, it says in or near porch, support structure with intent to commit arson or property.
So that's why the flag.
Sure, as far as, so I have a jury instruction, preparation to burn dwelling, no aggravating circumstance. That, are those elements that we are, I'm supposed to be looking at? I'm trying to plug in. Back to you. Okay.
The testimony was that the flagpole in the middle of the lawn, it's nowhere near the porch.
It's part of the instructions. I just want you to plug in the elements based on the test for your.
And my argument is based on the video and seeing the defendants on the porch with the item that he's using on the porch and exits the porch, uses the item on the flag. The flag is that lit on fire, the porch is not. And it's relating that to the testimony that the witness stated of why the porch, what would have prevented the porch.
So the third element says that the property was a dwelling for a preparation. To burn real property. Am I reading it wrong?
The property is a dwelling?
Yeah.
Is that right, Judge?
Or the element third, that the property was a building, structure, or other real property, correct?
Correct.
Okay. Okay. So for count one, attempted second degree arson, first defendant, people have to show I was caution that the defendant burned, damaged, or destroyed by fire or explosive. Burning the property in this case, this is an attempt. So people are arguing that he attempted to burn the house. It says if any part of the home is burned, no matter how small, that is all that is necessary to count as burning. The property does not have to be completely destroyed. The home is not burned, it is merely blackened by smoke, but it is burned and discharged so that any part of it is destroyed. Second, people have to show that at the time of the burning, damaging or destroying the property was burned, that the property was burned, damaged or destroyed was a dwelling or any of its contents. Third, that when the defendant burned, damaged, or destroyed the dwelling or any of its contents, he intended to burn, damage, or destroy the dwelling or its contents intentionally, committed an act that created a very high risk of burning, damaging, or destroying the dwelling or its contents, and that while committing the act, the defendant knew of that risk in this regard. Count two, arson, preparation to burn the property. The defendant, people must show that first that the defendant puts on some kind of flammable, in this case it would be the lighter, in or near, in this case, the plaintiff witness's house. Second, when the defendant did this, he intended to burn, damage, or destroy by fire or explosive that home, in this case, Mr. Rogers' home. Third, that the property was a building, structure, or other real property. The question here is for intent. I know based on the video, because Mr. Rogers didn't know the defendant beforehand, he could identify the defendant, Mr. Rice, from the video. I'm going to take that into consideration. Had he not known Mr. Rice, and I would not accept that as part of the testimony. The question here is just intent. It's clear from the video that there was a little bit of a spark of fire on the American flag attached to the complainant witness's house. So I am going to find over on the simple fact that this will be a question of fact for the trial fact as to whether or not he had the intent to burn the actual building. As a probable cause standard, I'm going to believe that there's an associated risk with burning someone's flagpole that the rest of the house may be burned out. So I don't know what the actual intent was, but based off of testimony today in the video, he did light on fire that flag with the possibility that the house was on fire. So I will find him over on count 1 and 2 for attempted second-degree arson, as well as arson preparation to burn real property. So for the second case, will there be a separate complaint witness or the same? Oh. Absolutely right. You have a second case. Case 2260502. Whenever you're ready.
This time people call Roy Gutierrez.
I swear you sir, raise your right hand. You swear to tell the truth, no truth, and nothing but the truth.
Yes, sir.
Okay, the door opens right here in front of you. Once you have a seat, just make sure you speak up in the microphone when you respond. Okay? Ready, Mr. Griffin?
Good morning. Could you please restate your name for the record?
It's Roy Gutierrez.
And I want to take you back to the date of October 24th, 2022. Do you remember that day?
Yes, the day my house was burned, right?
I'm gonna object. The witness is asking the prosecutor questions.
What's the objection?
The proper answer.
Okay. Can you rephrase the question or ask the question again?
Yes. So
I'll say this to you, sir. If you don't know the answer, say I don't know. If you do, just state the answer. Okay?
remember the date of October 24th, 2022?
I'm sure I do, but I don't know the details of that day. If it's a day that the house was burned, I do remember exactly that day.
At 2208 Street.
That day, no, I wasn't there.
At some point, did you come to that location?
Yes, I got an alarm. So I checked my cameras on my phone.
Well, just before this, I just want to clarify, is that address in the city of Detroit, County of Wayne?
Yes,
And what is that address?
220K Street.
Honestly, is that your home?
Yes,
Are you the owner of that property?
yes, I'm doing
And did something happen that brings you into court today?
Yes, the house was burned.
And you stated that you were not at that location at the time.
Yeah, I wasn't.
Where were you?
I was in a park.
Say Oak Park or A Park?
Oak Park.
And when did you become aware that the home was burned?
I got an alarm on my phone.
Is that alarm attached to the 2208 Street address?
Yes,
Okay. And what does that alarm indicate to you?
that there's motion inside the house. So I checked my phone and I saw smoke.
On seeing the smoke on your phone, what did you do?
I knew what happened. I don't want to say something, but
What did you do on seeing the smoke?
oh, I raced to the house as fast as I could, and I called 911. Yes,
And you said you raced to them.
yes,
So you made the location on 2208.
yes.
And what did you see when you arrived at your property?
I saw the firefighters putting out the fire. Yeah, they were outside.
And were they able to put out the fire?
Yes,
Was there damage to your property?
yes, extensive damage.
Could you describe the damage to that property?
The whole front was burned. The whole inside was partially burned, and they had to break some windows. The soot got basically everywhere. So, I'm a little familiar with construction, so I knew it was bad.
And does your property have security cameras?
Yes, it does.
Were you able to review those security cameras?
Yes.
And I would ask to show video. That's kind of the same procedures.
That's fine, but I'm gonna object to the foundation for this video.
Well, I don't know if he's delaying it or not to say whether or not.
That's fine.
And approach him. For identification purposes, I'm just going to show you a few seconds of this video. For the record, starting at 0 seconds. For the record, I paused at 6 seconds. Are you able to recognize this video?
Yes,
How do you recognize this video?
that's one of my cameras on the porch.
Did you review this video?
Yes,
Did you review this video with anybody else?
I believe with the police and with the insurance company as well.
And does this video appear to have been substantially altered in any way?
No,
There appear to have been material deletions made?
deletions, what do you mean?
Anything deleted out of the video?
I mean, right now it's frozen, so I have no idea.
Your Honor, I would move to admit as people proposed exhibit 1 of this video.
And I would object on that as to authenticity. This witness has no personal knowledge. He was not there at that building or structure at that time. He was in Oak Park.
Okay, so for the video being his and him providing it, he can lay the foundation for authenticity as far as identifying the defendant and witnessing. I believe that'd be different. I don't know what's going to be said about that, but if this is his video and he did not alter it or change anything about it, I would allow it. He can lay the foundation for his own video from his own home. Is it correct that you did not change or edit any of the video?
That's correct.
Okay, I will admit it over an objection.
People's exhibit 1, I skipped ahead for the records to 9 minutes, 7 seconds. For the record, I'm pausing the video at 9 minutes, 23 seconds. Is there anybody that you recognize in this video?
Yes,
And who is that
it's
individual?
Paul Rice.
And how do you know this individual?
Because I have so much video of him going back and forth on the street.
I'm gonna object. I'm gonna object. This is an improper identification.
Do you personally know this individual?
Yes,
Have you encountered this individual before?
yes.
For how long have you known this individual?
For about 3 years.
Is this individual present in the courtroom today?
Yes.
Could you please point out that individual and identify what clothing they're wearing?
Right there, it's a green shirt, I believe.
I'm gonna object. Yes, he's identifying Paul Rice here in the courtroom, but he's not identifying him on that video. And the video has a person with a hood on and a hat on. You can't even see the person's face in that video.
I don't know that.
Okay, well, this is supposed to be played in open court, I believe. So I would ask that the judge be able to see the video.
So I can restart.
Sure.
Starting from 9 minutes, 6 seconds. Pausing at 9 minutes, 24 seconds. So how are you able to recognize this individual?
Everything, the walk, the clothing,
Voting.
yes,
Have you seen this individual wearing this clothing before?
yes.
I'm gonna object. You don't identify people by clothing. This person in this video is wearing black pants and a black jacket. 90% of Detroit is wearing black pants and a black jacket.
Well,
Hold on, sir. What's the objection? This is still, let him finish his question about the identification.
When did you last see this individual wearing this clothing?
the same day or a few hours before with the face uncovered, so it was clearly him.
And you stated you have known this individual for 3 years?
Yes,
Does this individual live on the same streets?
yes,
Where does this individual live?
next door,
So is it fair to say this individual is your next door neighbor?
yes.
Mr. Honor, may I proceed with it?
Yeah, yes, and that would be for me to decide whether or not his identification is sufficient, but I'm going to overrule the objection based off of the witness being able to testify that, and on what he appears to be the same clothing as in the video, and his next door neighbor. And at that point, based off of that, I'm going to allow for identification.
And what is the defendant doing in this video?
He's pouring a liquid, which I imagine is gasoline, because,
Well, he was pouring a liquid.
Yeah.
Jack, speculation. What, I didn't hear what you said, pouring a liquid.
which I imagine is flammable liquid.
Okay, just speak to what you know.
Pouring a liquid.
And for the record, restarting the video at 9 minutes, 24 seconds. And when was this video taken?
Was that the night that it happened, I mean, over time,
The date.
they, I don't remember.
You said you made the scene, so your house was on fire.
Yeah,
Was your house on fire at any time prior to this?
no.
And what did you observe in this video?
Yeah, that he set the house on fire and, then the whole front, but.
And when you say he, are you referring to the defendants?
All right.
And this, just to clarify, this was the front porch of the house?
Yes, that's correct.
And again, just to clarify, what portions of the house were burned when the fire, department put out the fire?
The whole front, part of the inside, and the rest of the damage was water and soot, which basically got the entire house with some sort of damage.
Your Honor, I have no further questions.
You identified my client as the person on the video. Are you able to see anybody's face in that video?
Yeah, part of his face,
You can see his face?
part of his face.
Okay. And you see part of a face? What part of a face do you see?
Lower part,
What part?
lower part, it's kind of grainy, but you can see a little part of his face.
Can you describe what part you see?
I would have to look at the
Can you
video.
look at it again? I want to see what part you see. I want to hear what you say. So. That's all.
You see a little bit there on his face, raising his head a little bit.
All right, so you just watch this video. Isn't this person's head downcast the entire time going up the stairs and on the porch?
That's correct. But let me just
That's
make it
correct,
clear.
right?
Yeah, his face is a little bit. going
All
down.
right, and the person is wearing a hoodie.
That's correct.
The person is wearing a baseball cap
No, it's a hoodie.
and a baseball cap.
I don't know, I have to
Can I
look
show
again.
them again? And a mask and a face mask.
I don't believe that.
Can
So,
you
okay,
look
so,
at it again?
yeah.
You see a nose.
Yeah, but I'm saying, I don't, I didn't
All you
notice a face
see,
mask.
all you see is a nose,
No, I said I don't notice a face mask. That's it.
but all you see is a
I
nose.
I see some outlines. It's not clear, but let me make this clear. My identifying him as four rights is not based on that. It's based on different factors that puts it all together and it's clear that it was him.
I see, it's outside factors.
So that is all factors, that and other factors.
But you're not identifying him from that video.
Probably I knew it was him because of the walk, because of, I saw that on videos before I saw some of that clothing, I knew it was him immediately. But then I went back to other videos just to triple make sure. And it was clear there was
All
him.
right, so this happened at night, right?
Yes.
And you said you watched the video from 2 hours prior and saw the same clothing?
Yeah, well, after the fire happened, I started watching all the videos.
So for 2 hours prior?
For a few hours prior, there's a whole bunch of videos, even the day before. I started going from as far back as I could and
So I'm
putting
gonna,
pieces together.
and Your Honor, I'm gonna object, all that's not really relevant. This is about the ID on this day, on this porch, on this day. Did you see, all you saw was a nose, is that right?
Yeah, I mean.
Is it yes or no, sir?
Yes, I saw outlines of the face, that's all.
But you did indicate all you could see clearly was a nose. When?
No, I
On the
saw,
day on this porch of the incident.
No, when did he indicate only a no?
When he was watching it for the third time, we approached with the video the third time.
He's saying outline.
yeah,
But the only part that you clearly could see was the nose, is that right?
well, everything is clearly seen, outlines, basically what you see is outlines.
Tell me what part of his face you saw an outline. Because I just want to make sure that we're seeing the same video, because this person on your porch.
Yeah, when he's coming out.
Was face down.
Yeah.
There's a hoodie and a baseball cap with a brim, right?
I didn't know what baseball cap. I don't know, it's kind of dark in here. For me, I just saw a hoodie. Maybe I didn't pay attention to that, but I'm concentrating on trying to identify the face.
And the face is, and the
Yeah,
head is
it's a
down,
little bit down,
facing
yeah.
down, right?
Yeah, partially, going up and down.
I didn't see an up and down. You saw an up and down?
Yeah, when he's going up, I mean, normal movement.
When he's walking up the stairs, his head is down, is that right?
Mostly down, yeah.
Okay, so all you could clearly see was the nose.
The outline, the nose and some outlines of
What
his face.
outline did you see? Let's just focus in on that. What outline, tell me specifically what you saw in his face.
Like I said, an outline means like.
What? What
I
part?
don't know, this bottom part of your body.
You saw the bottom part of his face?
This part here, around here, like with the darkness, it's hard to make out some stuff, and some stuff you can make it out. Let me make it clear. I wouldn't be able to make him out just for that. I had to look at the clothing, I had to look at the walk, and the direction that he came to.
Oh, okay.
So,
Okay, that's
so
fine.
between that,
All right, I think you answered it.
Yeah.
Okay, all right. And you made a statement to the police on October 31st, 2022, right?
yeah.
You remember that? You remember writing?
Yes,
Okay.
yes, I went to the
And you
police.
never indicated that you saw any part of his face on your statement, did you?
I don't remember.
Your Honor, may I approach with his statement?
Are you rushing?
Yes.
Yes.
Well, okay, so what is the question?
The question is that you made a statement close in time to the incident on October 31st, 2022. You gave a very detailed statement, 3 pages, right? 3 pages?
Yes, I guess, yeah.
And you never indicated that you saw his face, an outline of the face, the person on the porch, whoever that is, you never saw their face or outline of their face.
Well, I was 100% sure it was him, so I didn't feel the need, I said like, it's him. I didn't feel the need to say, well, I saw this part that it does, or the hairline, I knew it was him. For me, in my mind,
Okay.
it wasn't,
The question is, sir, did you include that in your statement, any
I don't
details?
remember.
Yes, sir, that's why I can answer
Yeah,
your statement.
I cannot read it honestly.
You cannot read it?
No, I should get glasses. Or I should, unless somebody can lend me some glasses, then I can read. It's blurry.
Your Honor, I'd like to move this statement into evidence to show that there's absolutely nothing in this statement saying that he identified any part of his face. He can't refresh his memory.
I mean, if it's not here, then it's not here, you know?
Mr. Carter, do you have a response to the President Nick's statement?
I do not believe that the defendant is so faulty on this statement.
He's saying that he didn't put it in there, right?
Oh, he did, Your Honor, so it's not in there, right? The description, you didn't give a description of his face.
Probably, if it's not there, probably I didn't. And I wouldn't be surprised if I didn't go into detail because I was so sure it was him. Because I know his walk, I know the clothing. I have already gone through the videos.
Okay, so you identified someone based off of clothing, right?
No, and videos.
And clothing.
And videos, clothing, yeah.
Clothing.
Yeah.
Okay.
Clothing is next.
And the face, and the
Mr.
face.
Gutierrez, 1 second. He's testified that he saw clothes that the defendant had on earlier. He knew of his walk. He saw the direction he came from the video. And that's what he based on as well.
All right, so what kind of clothing was he wearing?
Well, whatever clothing he wore when he burned the house.
No, I'm asking you, what kind of clothing was he wearing?
Let's look at the video again. I don't remember.
You don't remember?
It's a while back. I had a hoodie and, and whatever pants.
What color pants? You don't remember? You just watched the video
I
about 4 or 5
no,
times.
I think it was dark. I don't
Okay,
remember.
and then the clothing that you saw a few days earlier, what kind of clothing were those?
No, it was, usually I think it was a few hours before.
A few hours.
I went through so many videos, we verified this. So basically, the same clothing that he used to burn, I can go back on that video with his face clearly visible with the
And
same
I'm
clothing.
objecting foundation to all this testimony.
It's on video.
What's the question?
What, he's identifying my client through clothing. So I'm
What
asking,
was
the question is, what clothing was he wearing on the prior incident?
Dark.
Just dark clothes?
And a
Okay.
hoodie.
Okay, all right. All right, I don't have any other questions. Oh, no, yes, I do. This place, it's vacant, isn't it?
Right now, it's getting rehabbed. Yeah, it's
All
vacant.
right, but you do not live in this place, right? You live in Oak Park, or you were in Oak Park. Don't answer where you live. You do not live at this address.
Not now.
Did you live there at that time?
I would go there here and there, but after I had problems with him, I stopped coming because I was afraid that something was going to happen to my car.
Okay, so are you saying that you lived at this address 220 in Detroit? This was your residence?
Well, let me put it this way. I'm in the real estate business, so I stay at different places, so I will stay there some of the time.
So your driver's license and your car insurance went to
No,
220?
no.
220?
No.
So you were not living there then,
That's
right?
not my primary.
No, that's not your, no.
No, it's not my primary.
And no one was living there, correct?
There was a group staying there just before he burned the house.
They weren't living, no one was living
Yeah, at
there.
the time he burned, thank God.
Okay,
Thank God.
you bought this house from the land bank and you were fixing it up, right?
Yes.
Okay, I don't
Yeah.
have any other questions.
Yeah.
Just want to clarify. Have you lived at this address at certain points?
I would stay for a couple of days here and there, but after I got a lot of thefts happening.
I'm gonna object, that's not relevant as to whatever he's going into.
I stopped going after I had fear for my car, for my safety.
Yeah, so when did you stop living at this address?
And that's the objection, facts not in evidence, and he never stated he lived there. He's
He
not
said he
living
would stay there here and there.
Okay.
It wasn't his primary residence. So living, if you define it as being there as primary residence, no, he was not living there. But if you lay your head there at night, then he did every now and then, and a group was living there also. So as far as primary residence, you know, did you ever sleep there? Did you ever sleep?
Yes.
Not recross, as far as the group staying there, did you have a business for this residence?
Yeah, after I kind of out of fear about staying
No,
there.
it's just a yes.
Oh,
or no
yes,
question.
yes.
At that time, was it a business?
Yes,
And then you, of course, would have documents to substantiate that that was a business that you had at that address?
well, yeah, I also rented it out
Right, so
temporarily.
you have tax records and all of that substantiating that?
Yeah.
Okay. Is that a yes? I just want to make sure that was a yes.
Yeah.
You have the tax records and business records that was your business, that you rented out?
Yeah, that's it. No, I don't know if you heard like Airbnb, VRBO.
That's what you did?
Yeah.
And it was on that day of the incident?
No, nobody was there, thank God, that day. Nobody was there.
All right, thank you.
Thank you very much.
And this time we will move to bind over the defendants on all counts. This will be count 1, second-degree arson, and count 2, arson, preparation to burn real property. As we heard from the witness, he was alerted on his phone. Motion was detected through a security system at this address, 220 Haven Street, which is the witness testified to. He is the owner of, he sometimes stays there, he sometimes rents out this property. At the time, nobody was present there. He then made a scene on his calls 911. We were able to put out the fire, however, there was substantial damage to especially the front of the house, but also smoke damage and other damage inside of the residence. The complaining witness and reviewed the security footage from that evening, which was admitted into evidence. The witness recognized it as the video that he had watched of that evening. In that video, he was able to identify the defendants. He was able to do so through seeing the defendants wearing similar clothing just prior to, like 2 hours prior to the incidents. From the way the defendant was walking, to the parts of his face that he could see. He has known the defendants for 3 years, and as he stated, this is next door neighbor at that location. And so also from the direction that the defendant walked up onto the property. The witness then stated, as we saw in the video, he watched the defendant pour a liquid onto a front porch and then lights that liquid, causing a fire to the front porch area. The same area was substantially damaged when we got there. For probable cause of the
I reject to bind over on all counts. In this instance, the witness did not personally observe anything. He watched a video. There's a problem with identification. The witness himself said he did not identify him from the video. He stated that he identified him from other circumstances. He made mention of seeing my client on video with clothing, not very specific, dark clothing with a hoodie. You can't identify somebody by clothing. That's improper identification. It's not allowed by law. He did not see his face in his statement that he made close in time on October 31st, 2022. He gave zero details about the person's face. The video clearly shows, which is in evidence, a person wearing a hoodie, a baseball cap, and a face mask, going up the stairs with their head down. You do not see, there's no way anyone can see the face, and it's in evidence. So in order to bind over, there has to be an identification. And yes, the witness identified my client in court, but he knows my client. that he did not identify him as the perpetrator. As far as dwelling, I would argue that this structure is not a dwelling. It's not anyone's home. No one lives there. It's not really clear that it is a dwelling. Maybe it's a business, maybe it isn't. There isn't any evidence other than the witness testimony. I also want to point out, go back to clothing. There's nothing in evidence. There's no video showing my client wearing similar clothing without a face mask close in time. So, Your Honor, for those reasons, I would ask that the charges on this case be dismissed.
Yeah, I do believe that there is a question of fact as to the identification. The witness was able to identify several variables for how he was able to identify the defendants in this video. Was included the walk with the defendant, the clothing that he was wearing, seeing the defendant wearing that clothing a few hours prior to the incident, as well as the fact that he does know the defendant. He's his next door neighbor, as he testified to being known for a few years. We would also state that we do believe this is a dwelling. It's testified to he has lived there at times and stayed there, slept there. He's also rented it out to other individuals who have stayed there. So, once again, we ask these to count on the
Okay, for dwelling definition states, dwelling includes, but is not limited to, any building structure for human habitation that was actually lived in or reasonably could have been lived in at the time of fire or explosion. I do think based on testimony saying that he lived there sometime and also rented out to a group which he described as Airbnb or VRBO, which are both home rental companies that satisfied as a dwelling for purposes of the exam. For arson in the second degree, first, the defendant, people must show that the defendant burned or damaged property by fire. In this case, it was ETR's home, which I just stated that I believe is considered dwelling. Second, at the time of the burning, damaging, or destroying property burned, damaged, or destroyed was a dwelling or any of its content. That was satisfied. Third, that when the defendant burned, damaged, or destroyed the dwelling or any of its content, he intended to burn, damage, or destroy the dwelling or its contents, were intentionally committed acts that created a very high risk of burning, damaging, or destroying the dwelling or its content, and that while committing the act, the defendant knew of that risk and disregarded it. There's enough testimony here to show that he definitely intended to burn, damage, or destroy that dwelling, that he did so intentionally from lighting up what seemed to be some type of flammable liquid. And I saw in the video the front of the house being caught on fire. So for arson in the second degree, that element is satisfied. Preparation to burn a building, or in this case, arson, preparation to burn real property, as you stated, count two. People have to show first that the defendant put some type of flammable, combustible or explosive material, liquid substance, or device in or near which would be used here as a property. In this case, it appeared to be a liquid flammable substance. Second, that when the defendant did this, he intended to burn, damage, or destroy by fire or explosive, in this case by fire. Third, that the property was a building structure or other real property. The question of fact here would be the identification. Mr. Gutierrez said that he, based on the video that he saw clothes that the defendant had on earlier that day, knew the defendant's walk because he knows Mr. Rice is known for 3 years now, and then he's also his next door neighbor, saw the direction that the neighbor was coming from, Mr. Rice being that neighbor. I think a key factor here is that that's his next door neighbor and knows him to a certain extent. Just because I know Attorney Robinson, you state that if someone has on clothing, that that's against the law to identify them based off of that. But there are instances where someone, in instance, an armed robbery takes place, and that person has on specific clothing, you see that person walking down the street, that raises the question, some validity as to whether or not that's the same person. So based off of the clothing, it was not described too well other than the hoodie and dark clothing, the same clothing that he had on earlier that day. He knew of his walk, that was his neighbor, and said he saw outline of his face. What the outline was, he couldn't really describe, but he said he knew that it was Mr. Rice. So with that, I am going to find Mr. Rice over also on this case, and it will be for both counts. And Mr. Rice, same date for your random information, will be 1 week from today, July 17th at 9:05 p.m. Frank Murphy Hall of Justice. It'll be on Zoom or in person, depending on who you get up to. I'm not sure who that is. Is there anything else before I bind over? No, right?